Lord, item
Item number 12.
Item 37, not today only, any day, Monday.
No, Lordship. I have an objection, Lordship.
Then when it reaches.
I'm the petitioner, Your Lordship.
You may be, but once it is posted, the
Lordship,
other
Lordship.
side opposes. We will not give.
But,
Lordship, item number 12.
That's why I was making a prayer.
Let us see.
Monday, if Your Lordship.
No.
Lordship,
Yes.
item number 12 kindly taken up 1 week after.
Only from 12.
Oblige.
No. On what ground? Nobody says you have taken for granted. The court to give adjournment, there should be a ground. Because once matter is posted, government incurs 800 rupees for posting it. What is the ground, madam? What is the ground?
Health issue.
But not health is not. You have manufactured that ground now. The court.
No, sir.
After seeing that works here. 2 weeks.
Oblige.
I maybe Parallel should make a mention, Lordship. Here the Kinel appeal is there, appellant in custody, but unfortunately on 3rd of January his mother expired. So
Mother expired.
Lordship.
You want furlough?
In that way only. I have annexed the copy of the that is a arbitrary card.
Tomorrow. Give a copy to him.
Yes, I will give enter copy. Yesterday also I am sure to take it.
State council should verify and tell us.
They do, thank you. I understand. Tomorrow.
No.
Item 1?
Yes.
Well, the included order is at Annex 17. Promotion. To the post
You have
of,
the sought for promotion.
yes,
From what post?
from the
Post.
Group D post to sorting assistant and postal assistants.
One is, presently you are in it, which position?
Group D post.
Group D.
There was a selection test, but it contains 2 parts. One is written, another is the computer-based test. The computer test has not been conducted in the selection process. That was the allegation, but not considered by the tribunal.
Group D post. From Group D to next higher level is?
That is postal assistant class 3, Group C.
Group C. To Group C. What is the mode of promotion? Is it by seniority come merit or merit come seniority?
No, it's a selection process.
Selection post.
Yes.
From merit come seniority.
No.
Huh? Selection post.
Selection process on the basis of the marks secured in the competitive examination.
Oh, it's a examination. Limited competitive examination. Read the rule. What it says.
You also will find at page 22.
22.
Annex of 1.
Yes. Yes.
The conduct of limited departmental competitive examination for LGO for promotion to the cadre of PS or SS. PS stands for postal assistant, SS stands for sorting assistants. In the RMS division, same post. In RMS division, it is called as sorting assistant. In postal division, it is called as postal assistant. Your Lordship will find next page 23. The revised pattern and syllabus. The revised pattern and syllabus of the said LGO examination has already been circulated by circular dated 10/3/2011. The same is indicated below. This is the advertisement and it has been indicated there. Paper 1, paper 2. And there 4.2, computer and skill test. This test has not been conducted during the process. On the basis
Being conducted.
On the basis of the first examination, merit list prepared and appointments given.
Whether conducting of computer and skill test, is it not part of the limited departmental examination?
This has been mentioned in the advertisement, it is part.
Therefore, it is part of that.
Yes.
But unless this is conducted, where is the eligibility to get promotion?
The first examination, paper 1, paper 2 conducted and promotion made. That allegation I had made before the land tribunal.
How can that be made?
And CST examination must have eliminated some candidates. I would have gone ahead. Had I passed the computer's
There is a
test?
reasoning behind it. Come to page 116, 116, para 5. What the reasoning assigned by the tribunal?
Yes, ma'am.
Out of 50,
Having considered the submission, we have perused the records. It is seen that syllabus for 2018 examination, it was mentioned that for paper 1 and paper 2 and your candidate has to secure 40%. I want to skip it off. Therefore, the ground taken by the counsel for the applicant that marks was added from CST is misnomer. I am not talking of addition of mark. It is only an elimination examination, computer-based. Marks have not been assigned to computer skill test.
therefore, whether one undertakes that examination or not, the candidate remains intact.
So after written examination, those who have passed computer test, their merit list ought to have been prepared. Yes,
For admission, it is coming now.
because it was once listed, I was out of.
Issue notice you provided for senior panel counsel.
Yes.
Even if the mark is not decided, it is an elimination examination. How can you deny promotion? The reasoning is, since mark is not decided, it's not necessary. That may
That is what my lord pointed out, that is page 116. But however, I'll take it.
may not be correct.
I filed an IL to reserve one post because it was reserved before the tribunal.
It was reserved.
Yes.
But this happened years ago. Selection of post.
By now, no advertisement, subsequent advertisement.
Then when there is advertisement, you come here, we will say,
All right.
don't worry.
Oh.
Now you take notice. Correct.
Issue must be. Yes. Learned senior panel counsel Shri signed so volunteers to accept notice for the OPs. First one. Counter may be filed within 4 weeks, failing which right to file one stands forfeited, and the petition may be taken up with face value.
All right.
Item 2.
May please, your lordship. My lord, in the day I filed the amendment petition of last occasion, your lordship directed to me 23/9/2025.
You want the quashment of the order of the tribunal?
Yes, my lord.
What the order says? Why were you before the tribunal?
My lord, the opposite party going to the tribunal challenging the order passed by this First Appellate Court and as well as the Revisional Court. That order was dismissed, that the dismissal order was
Revisional court or revisional authority?
Revisional authority.
Authority.
Yes, my lord.
Where don't bring court. Yes. What are the big facts? Give the foundational facts.
My lord, kindly say the annex.
Who are you? You were the OP number?
Open number 1, my lord.
One in before the tribunal.
Before the tribunal, I am the open number 1, 2, 3.
1, 2, 3.
Well, come to the page 46, annexure 11.
No, we'll come there. No problem. You tell the facts. Wherever you call, will come.
Yes,
But
ma'am.
now you tell the foundational facts of the case.
Yes, my lord. Well, what is the offense? The petitioner was resigned his service on 8/7/2014.
8/7/2014. What happened?
Due to the
He resigned.
resigned
Resignation.
under annexure 1, my lord. There is a notification, my lord, who was resigned in the computation of the 5 years of service, they are not getting the benefits, my lord. My lord,
Pension and other things.
no, my lord. Only 60,000. My lord, I'll come to the page, annexure 2, page 22.
Yeah.
My lord, got it?
Yeah.
Second para, third para. Now the condition of annexure 2, page 22.
Yeah, about return obligation is.
Now the condition of the above written obligation is that in the extent of the candidate not observing and not performing the terms of the service is laid down in memo number such and such, dated such and such closed, which the candidate hereby accept and not observing and not performing the regulation for the time being in force for Group C service officers of the Intelligence Bureau, the decision of the government in that behalf of shall be final, and the candidate resigning or leaving the service during the period is undergoing training except with the approval of the Director, Intelligence Bureau, or at any time within a period of the 5 years after completion of the training account of the resignation on any other reason, E/C, and or securities are forfeited for the refund on demand to the government of India, a sum of equivalent in his or 3 months of salary
Or 60,000.
60,000 rupees. They have not completed the 5 years of service. They are not got the 60,000 rupees. There is a circular who was resigned his service. He was deposited 12,000 rupees. Then his resignation will be accepted. That was not accepted.
Para 7. The detailed reasoning has been given.
The impugned order of the CAT.
My lord?
Para
Yes,
7.
yes. Para 7 of the impugned order, annexure 11. Para 7 detail, it has been elaborately discussed that the authority has committed wrong for which liability cannot be settled on the applicant, and since they have accepted the withdrawal of the resignation application, therefore the applicant is not liable for punishment.
My lord, I am going to the
My lord, para 7, a very short analysis has been made. If your lordship will be satisfied by this,
Read it out.
my lord, the applicant had submitted his request for resignation from service on 8/7/2014. On 18/21/7/2014, the respondents intimated the applicant that his case is under process and he was asked to pay 82,295, which was paid by the applicant on the same day in shape of deeds. Thereafter, the applicant was asked by the respondent by letter dated 29/10/2014 to pay 12,000 for incomplete 5th year as per bond executed by him. Since the applicant refused to pay the said amount by letter dated 19/11/2014, the respondents by letter dated 4/3/2015 intimated him that his resignation has not been accepted and the absence from duty since 8/7/2015 is considered unauthorized, and also directed him to resume his duty immediately within 7 days. The applicant received the said letter on 19/3/2015 and he joined only on 15/6/2015. Thereafter, disciplinary proceeding was initiated against the applicant. In between, the applicant submitted representation dated 19/11/2015 requesting to withdraw his application, which was considered by the respondents, and he was allowed to withdraw his resignation by letter dated 12/1/2016. The disciplinary proceeding ended with punishment order dated 7/1/2016, which was confirmed by the appellate authority as well as the regional authority. The resignation from service is a bilateral act. A person may have a right to resign, but the resignation is always subject to acceptance. An employer has a right to refuse an employee the right to resign for various reasons. Person holding responsible post in public administration cannot simply resign and walk away. They have certain duties. It is also a matter of contract where, notwithstanding the right to resign, that is dependent upon its acceptance. The respondents processed the application of the applicant for resignation and first intimated him to deposit 82,295, which was paid by the applicant on the same day in shape of DD. Thereafter, the applicant was asked by the respondents by letter dated 29/10/2014 to pay 12,000 for incomplete 5th year as per bond executed by him. Since the action of the respondents in asking for money from the applicant to process his case in a piecemeal and fair manner is not at all appreciable
And if they were asked applicant for money, the same should have been done in a single go. Since the applicant refused to pay the said amount by letter dated 19/11/2014, the respondents by letter dated 4/3/2015 intimated that his resignation has not been accepted and the absence from duty since 8/7/2015 is considered unauthorized and also directed him to resume the duty immediately within 7 days. The two charges in the charge memo relates to same. May just be there after my judgment.
I have read the full judgment now.
Yes, sir.
I am good in.
Obliged, my dear. Obliged.
Very obviously say that.
Obliged.
This matter requires consideration. So a deeper consideration is required. Will admit this matter. Issue. You are caveat or you are appearing on your own now?
I am appearing on my own.
Without
My lord.
filing caveat, etc.
Yes, my lord.
Issue notice. Learned counsel Sri so and so accepts notice for OP. Upendra Singh.
My lord.
First matter merits a deeper consideration. First up, it is open to the OP to file his counter, if any.
No, my lord, I will not file my count.
Different.
Because it is a writ of certiorari, my lord.
If you want, you can file. Otherwise, your right to file one stands forfeited. Otherwise, you will be
Only I will file one document.
whatever.
That.
Open to the OP to file his counter, if any, within 6 weeks, filing with right to file one stands forfeited. Forfeited. First up.
My lord, I have.
My lord, my lord, my lord,
My lord, I have.
my lord.
One stay up.
He can do it if your lordship permit him, my lord, he can do it. My lord, only one prayer, my lord. Because of this,
By an affidavit in IN number so and so, seeking leave of the court to amend, make a small correction in the numer of the annexure. That is,
11.
and it should tend to be in 11.
the prayer column. Like the reads as a prayer column in the application reads as schedule is there. In terms of schedule, first to produce that. Okay. Next one. The matter is at the stage of admission, and the rectification of by way of amendment is innocuous. First one. Therefore, ordinarily amendments of the kind are allowed, and therefore the same is the application is allowed. Leave being granted. Come on, petitioner to amend the pleadings in terms of by.
My lord, I pray a small request, my lord. My lord, since the petitioner is suffering because of this pendency of this writ application, he is not getting the promotion. My lord, I pray next week for hearing, my lord.
We post up pleadings. Next.
My lord, my lord, I have
Next.
a small prayer. My learned friend filed a contempt petition before this.
No, I have not filed any contempt petition.
Contempt number is.
No contempt. No contempt proceedings. Since your lordship is taking up the matter next week, my lord.
8 weeks, not next week.
My lord.
There are many older matters. Wait.
My lord,
Yeah. There are two judgments on this aspect of the matter. One by Allahabad High Court, another by Kerala High Court. Kerala High Court by Justice Mushtaq Ahmed decided one matter. So matter requires consideration. Yes, it's not taking Item 3. The matter from next week. Call High Court as requested. Next. Item 4. Next week. 4. Week after next. 2 weeks. Yeah.
Many pleadings. This matter is against the order of the Honorable Tribunal. What's it?
You can sit and argue, no problem.
This is page 113, Lordship. Take up the case in that 23/11/1983 was joined as postal assistant, Lordship.
Third financial relation.
Yes, Lordship. Here is the moot question is whether the charge sheet of Form 16, that is the final penalty charge sheet, issued on 15/5/2013.
It was issued on 15/5.
15/5/2013.
When
Entitlement
is dated?
23/11/2013.
23/11.
Subsequent, it will come on ended with the punishment of 2015, that is the negligence of duty, that is the 1 lakh somewhat punishment, Lordship. Here is a case, Lordship, that whether the financial upgradation is barred for the minor proceedings.
Penalty or not?
Proceedings. Your Lordship,
What courts have said?
yes, Lordship. Court has said that yes, subsequent punishment is there, then subsequent charge sheet is there in 2014, which is no access to this case. They have said that they have not given the MACP in 2020, 3/11/2013 is justified. Lordship, can you see? Next court, Lordship.
This is one judgment of this court itself.
Naresh Kumar Verma.
No, responsible, it is
Not for this court. There is
Not
one
this-
judgment of this court itself. That requires consideration. If you want to take notice, issue emergent notice. Are you senior panel concern or CGC? CGC. Well, not CGC, Mr. So-and-so accepts notice for OPs. First, OPs may file their counter if any within 8 weeks, willing its right to file on time for future. Post after 3 months. Yes. Item type.
May I please, Your Lordship, ma'am? Here the petitioner challenged the order of the Law and Tribunal under Annex 11, where the
Same.
But the Law and Tribunal, without giving the full benefit, part benefit has been given to the petitioner, madam. The fact of the case is that the petitioner was a GDS BPM and he was initially appointed in 1981. And there is some complaint and basing on that, he was removed from service in 98, basing on the criminal case. And ultimately, he was convicted in the criminal case, but subsequently, that was challenged and he was...
What happened? The last order is it was referred to mediation.
Madam?
It was referred to mediation, it seems.
No, mediation failed. The mediation report is there. Madam, mediation failed.
You were convicted, your client was convicted,
Thereafter acquitted.
and thereafter in appeal he was acquitted.
Yes.
What is the benefit you want to have?
From the date of removal till reinstatement, I am entitled for salary, madam.
How? You are not worked at all.
Now, the decision of this Honorable Appeals Court has already given that benefit to that in Rajnaran case that has been given, madam.
It becomes a service dice non because you are convicted. Understand first.
And your Lordship kindly consider.
Kindly understand.
Yes.
Once you are convicted, your employment goes.
Now, on the false allegation, I have.
Whatever, in the appeal you got acquitted.
Yes.
And then matter travels to appeal.
Yes.
In appeal, you are acquitted. Is it a case of honorable acquittal?
Yes.
Then show that.
Annexure 2.
Which is that?
Annexure 2.
So read where is that?
Page 43. Page 43. Accordingly, the revision petition is allowed. The impugned judgment and order of the conviction of the petition under Section 409 of IPC and the sentence passed there is under hereby set aside. The petition is on bail by virtue of this order of the court. He is discharged from the.
What is that? What is asked
Do
is,
you know what is the concept of honorable acquittal? Perhaps you do not know.
just see whether it is honorable acquittal or
There are two
acquittal
acquittals.
on technical grounds.
No, this the criminal division, this honorable court judgment, madam.
You do not understand.
Yes.
This is the problem. See, there is once a matter goes off to the trial, no question of discharge, number one. After the trial, either he is acquitted or he is convicted. That is in criminal jurisprudence. In service jurisprudence, there is another concept which the apex court treated in Ramlal versus so and so.
Yes.
Take out the 2021 judgment.
State of Rajasthan, yes.
if Ramlal gives the parameters, when it is a case of honorable acquittal,
Here is also the honorable acquittal.
you are not understanding the things. That is the problem. Since you do not know, we have to tell all these things. Take out the PC Rudrappa, which is that Rudrappa. Rudrappa versus state of Karnataka.
Your conduct leading to conviction is enough for the purpose of, departmental property. And even if you are acquitted, if it is a technical acquittal, it can't be said to be honorable acquittal. So therefore, you will not get the benefit for that period.
The department proceeding was not initiated.
I know that departmental proceeding is not initiated.
You are not working even without department. Therefore, read this PV Rudrappa versus state of Karnataka. You read it and come back. Okay? Division bench judgment of Karnataka. We can say it. And go to paragraph 4. Paragraph 4. PV Rudrappa versus state of Karnataka. There we have discussed, the court has discussed. When
check it up.
it is an honorable acquittal, you read and come back. Otherwise, we pass orders now. Maybe adverse to your interest. Or you want to read and come back.
Yes.
Counsel for the petitioner seeks a short accommodation for preparing more and come back in the light of PV Rudrappa, which was the state of Karnataka edition. Do you that citation? Is that a citation? I think.
2024, 401.
No.
Have you written?
Oh, before SCC?
Not SCC.
Okay.
KH. Neutral citation.
40?
Read and come back. Okay.
Item 6.
Item 6 down. Therefore, Mr. Smith, I pray next week.
Yeah.
Item 6.
Item 6, I pray on behalf of Mr. Smith, I pray next week, man.
Next.
Item 7.
May I pray not some other date minutes after 2 weeks?
After 2 weeks. On what ground?
That's really the thing that we have sold the property in favor of this opposition 6 minutes. But in the meanwhile, has withdrawn from that minutes. For that, we want 2 minutes. May amend the writ application. For that is the minutes, I seek some time.
Wait to amend. Section 52 will look after that issue. And it is a matter that happens list pendants. There need not be amendment at all.
We may also minutes for filing better writ application. Take minutes liberty from you.
That's the request.
Then you want to withdraw. I want
Your minutes are taking instruction from my party minutes.
withdraw with the liberty, whatever you want to file, you can file. Why to keep it pending?
As you lordship.
All right. Counsel for the petitioner seeks leave of the court to withdraw the petition with liberty to re-agitate on the same cause of action. First off. Next paragraph. For liberty having been accorded, will come on. Petition is when filing a re-agitate on the same cause of action by filing the better pleading. By filing the better pleadings.
Okay.
Liberty having been granted, petition is disposed of according to. Yes, sir.
Okay.
Item 8.
May I please, Your Lordship? Your Lordship, in this instant matter, on the last occasion, Your Lordship has directed to file an additional affidavit swearing that the scheduled property has not been auctioned off. Your Lordship,
Direct the opposite party to, what is your prayer?
Your Lordship, we are we had defaulted in paying the EMI installments, and for that reason, the opposite party had published an e-auction notice to get the scheduled property auction. Your Lordship, we are willing and we are ready and willing to pay off the entire pending amount or the outstanding amount with just a limited prayer that we just be given an opportunity to do the same. We will pay off the entire amount and let the scheduled property not be auctioned off.
Bank will do it, but what we can do it.
Your Lordship, that permit the petitioner to pay off the entire outstanding.
Stop. Is there any injunction by the court not to pay the money? You won't pay.
Now it is not auction.
No, Your Lordship.
Won't pursue your bank.
Your right to repay
Yes, Your Lordship.
is coupled with a duty to repay.
Indeed, Your Lordship.
So if you do not repay once the property is notified for auction, that is one thing. Your auction is no notification as such. Auction is not notified.
Auction and e-auction was published, but the e-auction failed, Your Lordship. Subsequently, the opposite party has recently approached the Learned District Magistrate Court of Cuttack.
The 14.
Yes, sir. Wherein we recently, before 2 weeks, we received a notice to appear before the Learned Court. And in that particular petition, they had prayed that because we have defaulted in the payment, let them be allowed.
Take position.
Pardon, Your Lordship.
They'll take position.
Indeed, Your Lordship.
Yes.
That before they filed that particular petition, we had approached this before this honorable court, stating that we have been trying to communicate with the opposite party and discharge all our financial liabilities, but it all went to vain. For that reason, we were left with no other option but to file this particular petition. That is why we need the leave of this honorable court to.
Under 13.2, 13.4. Once an order is made for taking possession, and to enforce that order, if the banker goes to financial goes to the magistrate court, is it open to the debtor to resist the proceedings before the magistrate on the ground that now you want to pay? What is the law on the point?
Your Lordship, this is my understanding. I can be completely wrong about it.
No, I'm not saying on that. What's the law? How the courts have decided?
Your Lordship, there's this case called Seller versus Bafna, wherein it explicitly talks about the right of the mortgager. Your Lordship, the right of the mortgage or the right to redemption extinguishes when the certificate of sale is issued in favor of an auction purchaser. Your Lordship, the process of sale has not been initiated as of yet. So because the e-auction has failed, the right of redemption still exists with the mortgager.
Notwithstanding order for taking possession.
Yes, sir.
Notwithstanding section 14 in any case.
Your Lordship, that is my understanding. Again,
That's all. We operate on our understanding, you operate on yours.
Yes, yes.
By the way, who is generally appearing for that Repco Home Finance Limited?
Your Lordship, I am not aware.
You deposit that money here.
Indeed, Your Lordship.
Okay.
Your Lordship, I just limited prayer. At least I will be given some few installments in order.
What was the reserve price fixed in the first auction notice?
Your Lordship, the auction notice has been annexed in annexure number 2.
No, we are asking no more.
Just reserve price.
Yes, Your Lordship.
Sure.
Yes, Your Lordship. 36 lakhs 58.
You deposit that.
You deposit that money.
Indeed.
Then we'll protect your position. All right.
Yes, Your Lordship.
That option notice is dated what?
It is 18/7/2025.
25.
Yes.
Issue emergent notice. First one. Counsel for the petitioner cross attention of the court to the interim order dated 25/9/2025 and tells that his client is filing additional affidavit. First one. She also submits that unless section 14 proceedings are interdicted for the time being, is the possession of the security property
is likely to be taken with the intervention of the magistrate, and therefore interim protection be granted in terms of application in IA number.
Your Lordship, I have not filed an IA.
Then what can we do? We can you file at least on application.
Your Lordship, I will file an IA.
First, at this stage, counsel for the petitioner very fairly submits that she would move an appropriate application for interim protection as a formality, therefore matter be taken up next Tuesday. Context. The affidavit filed, additional affidavit filed by the petitioner is taken on record. Taken on record. And the said affidavit held for a force. It is specifically stated that the subject property has not been auctioned as yet, and that only possession of is sought to be broken under section 14 of 2022. She, on being asked, counsel for the petitioner, on instruction of the client submits that the petitioner would deposit the a sum of rupees 35 lakh, 36 lakh to show in the registry of this court or in the or with the financial as may be indicated by this court. Call this matter next week.
Much obliged, Your Lordship.
One famous book on law of mortgages.
Yes, sir.
Tagore Law Lecture book. Banerjee on mortgages, law of mortgages. In that, this question is answered.
Thank you, Your Lordship. I will-
Look,
Yes,
that's it.
Much obliged.
Item 9.
Item 9, my lord. That matter is similar to the yesterday, item 2 to 11, but my lord, pass that order. That is a.
Yesterday, 2 to 11, same one. Is put on. Yeah.
Item 10.
Item done on behalf of Mr. Prince Patnaik, pray for 3 weeks time.
On what ground?
Ground Lordship, there are like certain documents of the CAT tribunal that needs to be submitted for the pleadings. So on the last order, so that was not obtained.
The request on. Finally. Yes.
Item 11.
Grateful, Lordship.
Last time I have taken time for instructions by those matters. My learned friend is filing in memo during pendency of the writ petition. The department already my lords granted my lords.
So petition has become
Benefit, extension benefits my
infructuous.
lords.
Not a big picture.
My lord, my submission before matter relates to excess benefit of technical resignation, man. Technical resignation. Technical resignation.
Okay.
My filing counter before Lord Tribunal, they have said that the order issued by DOPT is not applicable to games, man. And matter has been sent to Ministry of Health. Due to pendency of this repeats, Minister of Health has accepted the OM issued by DOPT. And in the meantime, Bhubaneswar has already accepted the letter issued by the minister.
All right, you got
They have to only extend benefit to me. They will extend benefit to me.
Your resignation to be accepted.
Benefit of technical resignation.
Benefit of technical resignation. What is the difference between technical resignation and resignation?
Brother, technical resignation means I have a tender resignation with the approval of my authority.
To be counted.
Yes.
That's all.
Ma'am.
And benefits of such service to be accorded.
Ma'am.
That was rejected by the tribunal.
No,
I am
And you are challenging.
Yes,
that.
ma'am.
Okay.
Now officially down.
The short grievance of the.
pardon. I have filed a letter of ministry and AN Bhubaneswar along with the memorandum that was taken to record by my lords and order passed on the last occasion. But this is that also this.
No, he is saying it is his petition.
Yes.
He need not assign any reason for withdrawal. See, Sheila Barse, it is his petition. Yes, dominously it is. Councillor, your CGC?
The senior panel, senior panel.
Panel counsel appearing for the petitioners submits that the petition has become infectual in view of letter memorandum dated
Circular dated 13/12/2025.
circular dated
13/12/2025.
circular dated 13/12/2025. Do you have that copy?
Already filed.
Yes.
Dated 17/12/2025.
13/12/2025. The circular dated 13/12/2025. First one. Next paragraph. The debt council submits, the say above circular reads as under. First one, below that. Sentence, no paragraph. Counsel for the petitioner submits that the relief which the OP wanted to have had at the hands of the CAT while the impugned order has been already granted by virtue of this circular. First of all, he assures that the consequential benefit would be released to the petitioner within what period? Again, no contempt and other things. Tell within what period you will settle? Will be settled within an outer limit of 8 weeks. First, in the above circumstances and with the above observations, petition is disposed of.
Item 12 has been urgent. Item 13.
Please, your lordship.
Yes.
Last occasion, my learned friend had said that he would cite some judgment to the effect that section 42(6) is an appellate provision.
Tell the foundational facts. We don't know.
Some facts are like this.
Who is the petitioner?
The petitioner, my lords, is the consumer of electricity.
Consumer of electricity.
His electric meter was inspected and it was found defective. Some internal defects. They did not comply with the requirements of the statute as to how defective meters are to be checked and verified. But they prepared a dump report and a penal bill was raised on me, which I challenged before the GRF.
Before the
forum, my lords. Grievance redressal forum. Under section 42(5) of the Electricity Act. Before the GRF, my contention was that this billing was improper because the meter had a defect for which I should not have been penalized.
When the meter was installed?
Meter was installed, my lords, much earlier, but it was inspected, my lords.
No, you have to answer because you are saying it is technical problem with the meter. If you take a decision, you should tell when it was installed.
The connection was taken. I have not taken instructions. But the inspection was on 25/2/2025. And that, my lords, they also say before the GRF that it was internal defects that your lordship will find at page 11, my lords.
Because of that defect, you are asked to pay rupees 59,187.
No, I was asked to, a penal bill was raised.
That is 59,187.
That is subsequent. That is the subsequent bill. That is the revised demand after the GRF's order. The initial penal bill, my lords, was for 2,13,338. That's at Annexure 3.
2,13,338. So this came to be set aside.
This, the GRF set aside. Your lordship may kindly look at page 11 first. The submissions of the OP in brief has been recorded. Complainant was a consumer under this division with CA number such and such, under such and such section of this division, in such and such KVA load, on dated 25/2/2025. The consumer's premises were verified, found that the consumer's meter was running 33.34% slow. Meter was not recording Y-phase current due to loose CT secondary screws
and neutral S2 down screws are missing. VIZ not installed.
May I submit with your lordship? Page 12 of the brief. Page 12 of your lordship's brief, if may. Your lordship may kindly see the bottom towards the page number 12. Towards the bottom, there's a table. There's a enclosed portion. If the complainant is aggrieved by either by this order or due to non-implementation of the order of the GRF in time, he or she is at liberty to make a representation to the ombudsman, and the address and the time limit is there. And the provision is 42.6. It is supplemented by the OERC Grievance and Ombudsman Regulation 2004, which prescribes that this is the time limit, this is the manner in which ombudsman is to entertain, and these are the powers of the ombudsman. And if after the ombudsman has to first hold a conciliation between the consumer and the licensee, if the conciliation fails, then the matter will be decided on the basis of the pleadings. Due to non-implementation of the order by the ombudsman, there is a proceeding before the OERC, just akin to the contempt. So the code itself prescribes the entire mechanism. Comprehensive code.
So he goes to ombudsman. He will not oppose on the ground that it is not maintainable before the ombudsman.
No, it is.
No, but he to go before the ombudsman, you have to leave him before time. Yes. Number 3. He goes before the ombudsman and the ombudsman takes up the matter. No force action be taken against.
Obliged.
I agree with it. Petition seeks to challenge the order of Crystal Forum made on 2020 and
Right.
2020.
Annex 1.
And they copy the law of sector. Your panel
I'm in panel with the risk.
what are your perceived definition?
I'm in panel with.
Okay. In all various ways that the information has got an alternate and efficacious remedy before the investment, and therefore he being relegated to the scene. First one, he also tells the court that writ jurisdiction is not invocable when such an alternate remedy is served. First, we exceed the scene. In the course of this petition is also the petitioner as provided in the
Section 42, subsection 6.
6 of
the Electricity Act.
2003. The Electricity Act of the 3 within a period of
2 weeks.
3 weeks. Within a period of 3 weeks. Giving open all contentions of the parties. First, since the petitioner is negative to alternate, no policy action shall be taken pursuant to during the same period of 3 weeks. First, it is open to the petitioner to seek detailed protection at the hands of the ombudsman if it's do exist there. First. No.
Copy may be uploaded.
Today. Okay.
Item 14.
The constitutional Rashmi direction.
Yes.
Dated 17/12/2025, my lord. The bank has communicated letter to the petitioner. Well, I shall make instruction in the matter. Rashmi, can you take up next week, my lord?
You are for the bank.
I've just submitted the bank letter for my note kindly.
What are you challenging in this petition?
But in fact, my lord, the petitioner paid a sum of rupees 39,07,000 for my lord, the total closure of the loan account.
Who are you going to be?
Like here, petitioner is a borrower. Yes. What happened, my lord? Let us kindly have a glance to the under annexure 1, page 12, my lord. There, my lord, one OTS offer was given to the petitioner to pay a sum of rupees 25 lakhs for closure of the loan account.
1 minute. What is this letter? Given a copy to him. This letter copy.
That is the letter to him already given, and they have taken asking for time to comply that letter to answer to, because that is specific. If any grievances, further grievances there, contact branch. Last line, my lord, kindly. Last line.
Relief has been granted by the bank now.
That regarding that letter, I shall take instruction, my lord.
What is that letter instruction? You are a borrower.
A borrower, my
If you
lord.
argue on merits, matter will be dismissed because of 2021 judgment.
That, my lord. My lord.
See, the bank is graceful and
Bank is very excessively graceful to you. And they should be happy with that, because on merits we cannot entertain your petition.
My lord, you also have glanced to the last order, 17/12.
Which this letter has mentioned.
No, in
mentioned.
the said order, my lord, also has specifically directed regarding the auction taken place by the bank, the status of this said auction, whether the auction is, my lord, still subsists or not, or whether the bank has prohibited the amount.
To the auction.
Minor auction, because he has deposited substantial amount, so bank has returned the amount and
return the amount to the auction purchase.
Auction purchase.
So there is no option for rectifying now.
No.
you pay the money.
Auction has not been fortified.
Only, Lordship, kindly have a glance to the, my lord, the OTS offer.
See, OTS and everything, we will not decide all these things. OTS, they are graceful, they are accommodating you, go there, and in view of this letter, they may close the account and finish up everything.
Any clarification?
What happened, my lord? The petitioner, my lord, submitted the OTS offer pursuant to their offer. That I am ready to deposit, my lord, 25 lakhs within the time. They rejected my offer on the ground that it is not viable. But the other ground was that it is beyond the time of the, my lord, OTS circular.
Correct.
But that circular is for the one financial year. That is,
if RBI circular is not applicable, then your OTS itself is an offer which they are entitled to reject under the Contract Act.
no, that circular is still subsists because it is for from the 31st March 2023, it is, my lord, there.
We are not.
Within that period, I submitted my proposal.
If you-
They, my lord, refused.
You argue in the hearing and dispose of the matter. No.
Because that letter, my lord, the petitioner has received, but it is not solved upon me. Let
No,
me
question
solve.
is not that. Question is maintainability of the writ petition. 2021 judgment of the Apex would say any grievance relating to OTS cannot be examined by the writ court.
It is not only OTS, my lord, because their own circular, bank circular, that it will till 31st March 2022.
Okay.
But they rejected on the ground that your OTS offer is beyond the.
Now, auction has not fructified.
Yes.
So your property which you have given way of security for the repayment remains intact.
Yes.
You should be happy with that. Rest of the grievances you work out with the bank sitting across the table.
Well,
They are agreeable for that.
That way we have called for him.
They rejected my OTS offer 25 lakhs. They gave that bank gave that your account will settle at rupees 25 lakhs. I submitted the offer.
But
they did,
you
thereafter,
after the expiry of the
that is there, my lord. That is why I submit, my lord. That time was there. But arbitrarily they rejected. But thereafter, well, I deposited 39 lakhs.
No, that makes no sense because.
Will be.
Makes no sense because that amounts to altering the invitation to opt.
My lord.
You were bound to pay within the stipulated period. You have not paid that.
Well, they assured me to pay that amount, though they have not issued the letter. I deposited 39 lakhs, my lord. Now they are saying that you have to pay the interest, my lord.
Oh, yes. It's a public money. Banking is others' money and my business.
Since the loan account is coming within the
If you want that we should dispose of this petition in terms of this letter, we'll agree. Otherwise, on merits, we are dismissing the petition. Covered by the judgment. If your grievance relating to OTS cannot be examined by the High Court, we are not the bankers. Your banker is he, not we. What do you want? No time will be granted. We can't spend the time that way.
The better would be we will take note of this letter and we will dispose it up so that some positive thing may come out.
I permit you to go before the banker, sit across the table and negotiate the deal.
That will strengthen.
Observe here.
Yes, that will strengthen your.
The grievance in the petition to a great extent has withered away because of bank's letter dated 23/12/2025, a copy whereof is produced this day, wide memo dated 7/1/2026. First one, the said letter reads as under. Okay? Reads as under. Next paragraph. Learned counsel for the petitioner vehemently argued that the complete grievance has not been redressed by the text of the letter, and therefore the petitioner should be permitted to negotiate the deal with the banker by sitting across the table. First up, with this proposal, learned senior panel counsel appearing for the appeal is agreeable, subject to policy guidelines.
Policy guidelines later are given. In case of any clarification, please contact.
That's what that's clear. Subject to policy guidelines. Next one, in the above circumstances and with the above observations, petition is disposed of. Yes. Sir?
Item 15.
The active matter is pending. Hearing on 9/1. My lord, there. After your lordship may keep after 9.
After 9. Your petition.
My lord.
Why adjournment?
My lord, because your lordship last time wanted to know about the position of the case pending before the DRT, my lord. That matter is listed on 9/1 for hearing.
Can I have a class?
Essay.
Well, essay 49/2024 is pending before the DRT cutter. The stage of the argument, pleadings have been completed.
What is the grievance here?
My lord, in this case, I pray.
Player, my
lord, omitting prayer number B, my lord, my petition stands against KVIC, my lord. What happens, my lord?
Yes.
KVIC, my lord.
For the village commission.
Redressal, my lord. My lord, I have taken in the loan in the year 1999, my lord. In 96, my lord. That they, and as per agreement, they will pay. I will pay 4% interest and they will pay 13% interest, my lord. But what happens, my lord? They did not pay the interest amount. Bank issue notice to.
But all these things are to be argued before the tribunal.
That is why your lordship asked to whether that matter as finally.
Oh, he says that it is
stage heard and reserved.
My lord, on 9/1, my lord.
It is heard and reserved.
My lord.
Stage of argument.
At the stage of argument.
They will start.
All these contentions permission to arrest before the tribunal.
All the only
But my predicament, my lord, what happens? Bank people are doing injustice for me, my lord.
That you
1 minute, my lord. when they have filed a OA application in the year 2009, my lord. What happens in the year that when they claim the interest amount against me and without segregating the amount claimed against KVIC, and I approach the bank in that you may adjust my fixed deposit amount. Bank people are not adjusted my amount fixed
Have
deposit.
you precisely the same point you might be arguing there also?
My lord.
You argue that we will permit you.
My
We will
lord.
say, just kindly understand. We will say the grievance sought to be ventilated before the court by the pleadings and the arguments can be treated if urged before the tribunal.
My lord.
With that observation, we will dispose of the petition because the essay is pending there.
Essay and original application
Is also pending.
My lord.
Yes, all these contentions you can take up there.
Good tribunal.
A lot of the DRT, they will not hear.
We will tell them. We will tell the DRT.
Well,
All right. Both the sides, having argued the matter for some time, are graciously agreeable to the effect that all contentions and grievances raised in the petition can be urged in the pending OA number 369 of 2009 and essay number
49 of 2024.
49 of 2024 that are stated to be heard on 9/1/2026. First of all, ordered accordingly and writ petition is disposed of. To take up all contentions.
Yes,
Obliged. The DRT is requested to give effect to this order.
Item 16.
The copy to be acted upon.
Well, this petition was filed seeking a direction against the London magistrate to dispose of my section 14 application.
Section
14 of the surface application.
before the magistrate. Which magistrate?
No, this is the Bolangir collector.
Have you got the instruction?
Lordship, I have not got the instruction, my lord. I have only issued my.
The apex court.
Well, that's RD Jain. This honorable court also the coordinate bench.
Lordship, direct.
The tribunal, the magistrate has immediately complex that order.
Yes.
The provision itself says 60 days, 30 days, 30 days. And
Last time we asked, what is
All Stein and company.
Yes, I have already issued the letter, my lord, on 31st December 2025, my lord. Not yet received any instruction. Lordship.
What instruction? Magistrate had to dispose it
Yes, sir.
finish the proceedings under section 14.
Lordship. Lordship, direct them.
and this has been numbered, my lord. This has been numbered.
Yes, all right. In few cases, it was not numbered. In terms of this judgment, the subject matter of this petition is substantially similar to WPC number 10628 of 2025 between Bank of India, Hon'Ble branch versus State of Odisha and a batch of other connected matters disposed of by a coordinate bench of this court. Void
21st July 25.
Void order dated 21/7/2025. 25. First. The
last was reflected.
The ultimate and the penultimate and ultimate paragraph of the said judgment read as under. Next paragraph it is. After comma. These observations are made after looking into the apex court decision in RD Jain and Company versus Capital First Aid 2023 1 ACC 675. First one. Next paragraph. In the above circumstances, this petition is also disposed of with the same direction as has been made in WPC number 10628 of 22 and other correct statement.
Item 17.
Made peaceful.
Yeah.
Let's be they ordered it 19th of December. Let's say directions were issued to seek instructions.
What is the subject matter? Say the foundational facts.
Yes, Millets. What has happened, Millets, is this. This company.
Borrower.
Yes, Millets. I was a borrower. Then matter went on before DRT. DRT proceedings were there.
What is the amount of debt?
Plus the amount of debt was somewhere around 7 crores.
That when debt was contracted?
Millets, that was that, if I may kindly just, it's a very narrow compass, Millets, very narrow compass. Bank files an application before the DRT saying that please withdraw my application. DRT dismisses it, saying that bank says matter is settled, files an application to withdraw it. DRT
OA was pending.
OA, bank says
the bank, OA filed by the bank, during the pendency you appears to have settled the matter.
Yes.
He moves an application to withdraw. The
DRT, bank doesn't have a problem.
My lord only say prayer may be allowed. Because
NCLT proceedings are pending.
NCLT proceedings, as your lordships knows, there's a resolution plan that was given by me under the insolvency and bankruptcy code.
That is nothing to do with this OA.
No.
As per the resolution plan, I have settled bank's debts. Therefore, the bank goes and it's a
withdrawal of the OA.
Yes, bank and DRT withdraws.
We'll record his statement and put it up.
Petition prayer reads as under. First off, learned counsel appearing for the petitioner borrower vehemently argues that when the lender bank had moved an application seeking leave to withdraw OA number?
OA number was 479 of 2015.
2015, all dues having been settled by and between the parties, the DRT could not have declined the said application. First off, he cites decision of the apex court, which is that judgment, Sheila Parse.
Yes.
Versus so and so. There are too many Sheila Parses. Just look into dominant, please.
Dominance latest.
Dominant first. He also presses into service the general principles enacted in Order 23, Rule 1 or 3?
It will be Rule 3, Miller.
Rule 3.
Rule 1, Sub Rule 3. Rule 1, Sub Rule 3.
23, no.
Order
23. Of the
Order 23, Rule 1, Sub Rule 3.
Just correct. CPC uses the word abandon.
Abandon.
Order 23, Rule 1 of CPC, Ashwin CPC 1908, to the effect that the dominant litis has the right to withdraw the lease unconditionally, provided that liberty is not sought for. First. Next one. Learned senior panel counsel appearing for the banker, for the bank, very fairly submits that the submission of learned counsel for the petitioner is true and correct, and that the petition prayer be granted. First one, in view of this fair stand, nothing more needs to be done in the matter. Next one, in the above circumstances, the DRT, so it's with that DRT is hereby requested to permit the bank to withdraw OA number
479 of 2015.
Fourthly, and unconditional. First one.
Let's say, if I may kindly request, Millets, if your lordship will make it time bound before the DRT.
Forthwith, we say.
Forthwith. You move application tomorrow.
months.
No, it's already pending now. When that application
is pending.
It's pending and that petition has been.
I 26 and 25.
MA 26.
In fact, the apex court in Kalinga Tubes
Yes, Milord.
said the orders that are put in challenge before the court in 227. It's a 227.
220.
The writ report itself make that order. But we are giving, we are requesting the final.
Obliged.
Item 18 and 19 have been adjourned. Item 20.
May I please, Your Lordship? Lordships, I appear for the petitioners in item 20, my lords.
20.
Item 20.
Okay.
Lords, this is the matter regarding the forfeiture of the auction purchase amount, my lords.
Sorry. Item 19, I have instruction to appear, my lord. On the item date, my name may be indicated, so that I.
No, we have been put up that matter. No, so the adjourned first of
19.
Okay, 19. You mentioned this name. Please mention this name. Yes. Okay. Give your name. Just.
My lords, may I continue with your permission? Lordship, in this, the auction amount, the 25% of the auction amount.
Who are you? You are the borrower.
I am the auction purchaser.
Buyer.
Auction purchaser. The amount that has been.
What is the difference between buyer and purchaser?
My lords, I'll have.
Buyer is in Transfer of Property Act when immovable property is concerned. If the Transfer of Property Act does not use the word purchaser at all, purchaser is under the sale of goods. It also uses the word buyer. But immovable property is concerned. We should use the word buyer, buy, sell. Sell.
I stand corrected. I am the auction buyer.
Since you are a youngster, I'm saying.
I take into consideration. I'll have a look.
Why do you want refund?
Because they think it is an illegal forfeiture. Because what has happened is that when I went with the bank manager, the borrower, he did not allow me to enter into the property. And meanwhile, what he has done, there were two kinds of auction. One for the property and that is immovable, and one for the plant and machineries that were movable. And meanwhile, what he was doing is, he was, first of all, he is obstructing the possession. He was not allowing us to enter the property. And behind the back, he was also selling the plant and machinery to some third party. And for that, my assets, what I have purchased in the auction process, that are not being protected, by the bank. And for that,
auction was held on which date?
Auction 13/6/2025. Your Lordships, the auction notice is at page 21.
13/6/25.
Yes, my lords.
You were the highest bidder.
I was the highest bidder.
You remitted the bid amount when?
My lords, on 13/6/2025, it was confirmed, my lords. I deposited 25% on 16/6/2025.
25% on 16/6.
Yes, my lords.
And remaining amount?
Remaining amount has not been deposited, my lords.
Not been deposited?
Not been deposited.
When you were supposed to deposit it?
My lords, they granted extension till 10/9/2025, my lords.
Now, if the possession is given to you, you are ready to deposit that.
Yes, my lords. My lords, and even
you gave a legal notice.
Yes, my lords, and even my lords, there's a letter, my lords, at page 36.
You never did Congress.
You are appealing. It is your duty to give the possession.
Yes, yes.
Of the property from all encumbrances to the auction purchaser. He has paid substantial amount. Either you give the possession, he will pay the money, or refund the money. As simple as that.
My lord, my respectful submission. If you would have been deposited 100%, then he is entitled to get that. If he paid the 25% and not paid the 75%, the 25% amount must be forfeited in view of sub-rule 4 of rule 9 of the security interest rule. That is my responsibility. I will take the instruction.
Take instruction, sort it out.
The only predicament is, I was granted extension till 10th of September 2025.
Light to one cannot be granted.
He is assuring you that the possession will be given. You deposit the entire money here, we'll see. Then we will refund it.
My lords,
Entire option money he has to deposit.
May not give you the take instruction.
What is the position? Let them sort the copy of the read petition. I will take the instruction. What is the position of the deco?
No, now the auction has not taken place.
I am not aware of just now.
Subsequently.
Subsequent action is not.
Subsequent auction has not taken place. Property with you.
That
You want to accept
That I will have to take instruction.
No. Issue emergency notice. Learned Penal Council Sri.
From the Standing Council of Union.
Standing Council
of Union.
Of Union Bank of India accepts notice for the OPs. Which OP?
Millards, OP 2 and 3 Millards. OP, sorry Millards, 1 and 2.
1 and 2. 3 notice has to go.
Millards, it's only OP 1. Sole OP, Union Bank of India. Is the stress assessment.
Petitioner to copy of the petition along with all the documents on the Learned Standing Council immediate person. All this matter we talk to next.
Yes,
this is how advise your client not to precipitate it further.
I'll serve a copy in the course of the day.
Yes.
Much obliged.
Item 21.
Yeah.
Your Lordship, the appellant is convicted under section 302 IPC.
Press admission. Foxo is not there?
No Foxo is there, and also free from the charges.
You have an application for
realization of stay and for the bail.
Realization of fine stay and application notice on the application IA number 3524 of 2025.
Item 22.
Separate order.
Detail is given. Sub item also.
Yes, yes, Mr. Pradhan. You have an application? Realization of.
There are two applications. I have filed an application stay of realization fine and the bail.
That is allowed, and insofar as the bail application
receipt of LCR
notice, call for CCR. Yes.
Item 23.
Yield criminal appeal.
Matter 23 is a 3-day delay.
Delay condone. Delay condone. Admit. And there is no application. There is not.
Item 24.
And appoint the MAC query from the panel.
Item 24.
Same order in
24 is 87-day delay.
Delay condone.
But initially the offense was 370 and POCSO Act is there.
Notice.
And in the
to the informant.
But in the judgment only 302 is the conviction under the 302.
POCSO is there.
In the POCSO is there, but it is the
acquitted. Notice is not required.
That's why
okay. Simply admit, and there is no application. Appoint MAC query from the panel. Method call for 3 years.
But delay condone, my lord.
Delay is condone. Yes. 41. Yes. There is such an order. Yes. Yes. Yeah. Item 41. We'll come back in a couple of seconds.
the opposite parties. And
25.
25.
Ah.
I am appearing for the opposite party, praying for 2 weeks time to file objection to the delay condemnation petition filed by the petitioner.
How many days delay?
404.
When the application was given to you?
The application recently the party came to me and because earlier.
Recently is a very elastic word. When it was given to you?
It was sent. Notice was issued. Notice the party.
Where have you received the notice?
When your party received the notice?
I don't know the party when received, but it came after the 1st January.
Without knowing that, you can make submission. Well, the older matters are still pending.
Only 1 week time maybe.
No, what for?
They are the petition.
Whatever objection you have, you tell us. We will treat it now. What's your objection? Older matters are still pending.
Yes.
And how can you dismiss matters on the ground of delay? What the party will feel? Keeping all the cases in the cupboard of the court for years.
Yes,
and if we dismiss this, what sensible people will speak of the courts?
Yes, sir. The objection to the delay continuation petition is that past the writ petition was listed earlier on 21st/3/2022. Your Lordship comes to the order number 6, wherein the matter was taken up through hybrid mode. Learned Assistant Solicitor General for the petitioner contended that the file is not available with him. Yeah. On his request, call this matter after 2 weeks.
Yeah.
Then the matter was again listed on 7/4/2022, Your Lordship.
Yeah.
Order number 7. This matter was taken up through hybrid mode. Mr. A. Pradhan, Learned Central Government Council, states that he does not possess the file, therefore he seeks for adjournment. Even though the Learned Central Government Council has appeared, but the brief has not been constituted. Since it is an old case of the year 2014, this court is not inclined to grant adjournment. Accordingly, the writ petition stands dismissed.
We have
then the
matter pending. We have 2007 matters pending.
Yes,
and all they are stacked in the court cupboards. If they are still pending, it is not that suppose if the application was filed in time, we would have heard and decided the matter. You give some books to the library. You appear for the.
Then I'm coming to the rate. Then I'm one. An interim application, sir.
Matter, it was a matter. Or mechanically we will simply restore it and waiting for another 10 years, another 15. Now
Yes, for the department.
And if we will restore it and get it and make it immediately into the contract.
Yes, ma'am.
Yes, ma'am.
On the same day, your Lordship may.
The question is, you have sought for restoration of recall of the order 6 made on 6/1/2022. We recall that. What is the effect?
Earlier
Petition will be heard on.
No.
Earlier order 7.
You have not sought for recall of the earliest order, the first order, which 7/4/2022 it was made on.
That was dismissed.
So how is
dismissed for your
non-prosecution? That remains intact because you are not prayed for recalling of that order at all. There are 2 dismissal orders.
Yes.
One order of dated 7/4/2022 dismisses your petition.
Yes.
Then you made an application, and that application for recalling the earlier order, that application came to be rejected on 6/1/2023.
Now your application seeks recall of this order. Even if this order is recalled, that order remains intact.
In fact, my one IA was there. IA number 103 of.
So we have to see the conduct also. Union of India 6 times saying that we don't you have petition or your own petition. You say that I don't have a copy. And court says that reconstitute, argue. Thereafter you don't do anything. Court dismiss it because of your seeking time. Adjournment was refused and dismissed in report. Thereafter you move an application for recalling of that order. That was turned down. And now you move this application saying that rest of the petition. Only without challenging the earlier order,
first order
dated 7/4/2022.
Only because of change of counsel, this is what happened.
No, brother, you have to make another application.
Yes, my lord.
For recalling that order. Otherwise, that remains intact. By allowing this application, nothing happens.
I will file an IA that effect.
IA and bring 5,000 rupees payable to him.
I will not.
Follow 2 things. Yes. At the request of the DSGI.
DSGI along with J. Panda.
Yes, next. 41. Yes. Item 41. Yes.
Item 41, in this case, my other senior DSG and ASGI is appearing, my lord. Due to some personal difficulties, DSG is out of station and please for time, my lord.
Not sure, it's an unfortunate case where I come from Delhi, they know that. And spending money coming here.
Sure.
No, they will say sometime means not some day. No, sometime.
No, sometime
afternoon.
No, sir, 1 week after he is out of station.
Then you pay money for flight charges to the council. You knew that he comes from Delhi. And you did not inform your friend saying that you don't come tomorrow. All the way he comes here and he goes back.
Sorry for that, but
no, don't say sorry. We are very happy. You'll be here.
I pray for one adjournment.
You give a flight charge. The bar member should have courtesy to each other. Let him come from Delhi, eat pani puri and go back. Or rasgulla and go back that way. No, that way does not work with him.
Well, learned ASGI who is appearing from Delhi, he told me to take time, my lord.
We'll give time.
So
we'll give time to you. Whatever time you want, we'll give you, provided you reimburse the flight charges. He does not come here for playing. Can you come again?
I will have to, your lordship, but your lordship, it would be at their risk and peril in the sense that there is a contempt petition pending. They themselves wanted, they made a big gulla for that. And
which contempt matter it is?
Your lordship,
don't precipitate the contempt matter.
Yes. What happened was not.
Are you agreeable with this proposal? We'll tell them not to precipitate the contempt.
The contempt is filed by me.
By you?
Yes, because I was the applicant, I'm the respondent here. What was happening was this officer was transferred.
Because there was a direction for personal appearance.
Yes,
so
there was direct personal appearance. Thereafter, everybody.
ASG came and argued the matter.
And that's what it is. And therefore, this date was fixed specifically with consent of all the parties at 12 o'clock.
That's the reason generally we are reluctant to give interim orders. Once interim order is given, then we keep on asking for adjournment.
And only it was your lordship that on only that particular date the exemption was given. Therefore, that exemption should not be continued, your lordship. And then it may be kept on 9th of February because on that date I'm coming again because I have some matters in the time.
On 9th we will have this matter.
You can have this matter on 9th February.
We'll have it on 9th February.
Okay.
You call this matter on 9th of February at the request of learned ESG.
Additional
Solicitor General. Mr. Raman. ESG. First. All right.
Can it be a time fix?
No, how we can? This is the problem.
Yes, I understand that.
Date we can fix.
Yes.
Okay.
I oblige you.
Right. Cuttack is a good place. You can have a round and
No,
go.
Dr. Shripad, I belong to Cuttack. I'm from here only. And I know I don't mind coming here. But only my father is still there, 94. He blesses me that way. I come every month once at least.
No.
But the only thing is the burden on the client, your lordship. He's not getting any pension from.
Next time you spend from your own pocket.
I did that this time. I did that.
That's the best.
Actually, I did that this time. Next time, let's see what happens.
Yeah.
Oblige you.
Next.
Item 26.
Vaccines. I find one IE. This is a public petitions, not of expert on past January.
1126, so far the IA is concerned, 63 of 2026, this is for interim bills.
Yes.
Have you verified?
No, let him solve a copy. By that, I will take
Yes,
instruction on that effect.
This is the card and the death certificate.
When
Yesterday I have submitted.
1 million.
the Kriya-
This is file on
Yes,
6/1, today is 7th.
Yes, that's a.
tomorrow? Whether is
No, I have solved the copy.
it's all right.
No, this is not of the.
Yeah.
This is the.
Can
Only is to.
verify it for tomorrow. We'll keep it.
Only 15 days.
The trial court will verify and give it.
Trial court.
Yes, yes.
Trial court will.
Yes, yes. Yes.
Where is that?
Saturday, then Friday will be.
That
This is from Bhadrak, as it appears from the card.
when she died? Gram Panchayat. No.
1st January, only son. Nobody is there. The labor camp.
We will allow subject to verify. Let the trial court verify.
Yes, yes, yes.
Let the trial court verify.
City remains.
Number 2026. Huh? Has moved substitution seeking infinite release on the ground that the mother expired on 3-1.
And this is 1/1.
In support of his contention, he has filed series of documents. Next is A1. For the reasons stated in the application, the same is allowed. Subject to condition that the trial court shall verify the authority of the document and release it on the condition in fit and proper. For 3 weeks, 2 weeks, 2 weeks. For 2 weeks. Petitioner shall surrender immediately after the expiry of 2 weeks, period of interpretation.
Item 27.
This is
In item 27,
there are 2 applications. There are two appeals.
It's a one
Jail criminal.
Okay.
Then
Why 2 appeals are pending?
jail criminal appeal first filed.
jail criminal appeal.
Then one appeal you can dispose it of.
Yes,
Well,
This is analogously.
Jail criminal appeal.
Which one? The earlier one will remain.
Yes.
No, both are jail appeals. No, one is jail appeal, then
Another is regular
criminal party.
Criminal appeal.
Party. The jail appeal we will dispose.
Jail criminal will be disposed of.
advocate will engage in it.
Jail appeal.
No advocate engage in jail criminal appeal. Jail criminal appeal will be no advocate engage in the jail criminal
So
appeal.
we'll dispose.
Yes.
If at all the same council will be engaged, because they have given the consent, that is a petition, and the jail criminal appeal,
Jail criminal appeal
he can take that
has been
petition.
filed. The order of the conviction and order of the sentence. Subsequent thereto, criminal appeal number 627 of 2029 has also been filed by the convicted himself. In view of the same, the jail criminal appeal 78 of 2018 is disposed. In the interim application, in the criminal appeal.
What's in copy, man?
Yes.
Yes.
Item 27.
May I please, Your Lordship? Lordship, appellant has surrendered in time, Lordship, after availing the interim bail.
The surrender certificate not
IA
filed.
3283, Lordship, for 15 days.
Surrender certificate not filed. Noting is surrender certificate not filed.
Will file, Lordship. By next week, we will file.
The interim order was
Interim bill issued for a period of 2 weeks. After
dated 1/12/2025.
yes, my lord.
Pursuant to the interim grant of bail by the order dated 1/12/2025, wherein counsel for the appellant thinks that the appellant is already surrendered. However, surrender certificate has not been filed. Let the appellant file the surrender certificate within a period of 1 week.
2 weeks, Lordship.
Please the matter of food.
I live, Lordship.
Item 28.
That will depend upon.
Yes. No, there is a letter from jail from the appellant for my engagement. That's
Flag G. Flag G. Who was appearing earlier?
Mr. S.S. Rai, who was it?
Sister, S.S. Rai was appearing. Now there is nothing. S.S. Rai, the prisoner's petition is listed today. Earlier, Mr. Siddhasankar Roy, too, was appearing for the appellant. While the prisoner's petition, the convicted has requested to engage Devasas Konda counsel. We represent him. The prisoner's petition is allowed. Have you filed a wakalat?
I'll have to file a wakalat.
Wakalat now. It's not there. Blanket wakalat is there. So that is also.
There is one other thing, my lords. It appears from the noting that the antecedents and
Yes, my lord. State has to obtain the custody certificate as well as the conduct of the
State is required to
There are
place of
records
records.
are available.
The antecedent. Have you got it?
Yes, custody and conduct both as well.
And then there was an instruction to the counsel for petitioner to obtain instructions regarding status of 3 criminal antecedents.
But now they have given.
I don't know whether it has been filed or not.
Now they have given.
I'll have to take the government.
What about the answer?
First is to the order of the 8. Which order?
1911.
First is to the order of the 8, 1911-2025. The IIC Nagar Police Station has placed on record the report dated 1911-2025. In the area indicating that the petitioner is involved, the convict appellant is involved in the 3 cases. The detail of which is furnished. The custody certificate is also placed on record, indicating that the appellant 1618 days. Means how many years?
From 18/6/2021, I am in custody. So it will be about
4.5 years. 4.5 years. the custody certificate indicates that the
4 year, 4 months.
appellant is in custody since
4 year, 4 months.
About 4 years, 4 months.
4 years, 4 months. The report is taken on record. Please the matter after 2 weeks. Report. After 2 weeks? Yes. Meanwhile, you file the local. Meanwhile, Mr. Ponda to file local.
Item 29.
In item 29, my lord directed to obtain the instruction regarding conduct of the appellant inside jail, my lord. I have obtained, my lord. That is good.
Custody certificate
Already there.
Custody certificate qualified also filed.
Custody certificate flag D.
Yeah, already produced. There's a period of custody?
5 years valid.
My lord, eyewitness are there.
Here it. Versus to which order was that?
The deceased is the wife of the accused, my lord.
Which order? It's certificate to which you have filed.
15/9/2025.
Persons to the order.
Order number 49.
14. Order dated?
15/9/2025.
This is the order dated also. The jail superintendent, Athagad Station Jail, is on record report indicating that the behavior of the convicted in the jail is satisfactory, which is taken on record. Please the matter for bail application to be heard.
There are my lords, but here there are 2 eyewitnesses and the police officers witness are there. So, and the deceased is the wife of the present appellant. The conduct also, my lord, is there. So bail may not, my lord, I have heard it a couple of times.
But after
My lord, add it to the hearing list. If it is there, he will be.
Please the matter for finality.
My lord, that's
Final hearing, my lord.
my lord.
Item 30.
In this case, my lord, the bail has been heard, and your lordship has directed for obtaining a report. That is order dated, my lord, 17/9/2025.
17?
17/9/2025. Yes, my lord, because the appellant is suffering from psycho disorder, my lord. Psycho disorder.
Yes.
Regarding that present health condition, as has been received from the authority, my lord, that is hale and hearty, my lord. According to our assessment, it was found that the accused is maintaining well under the regular medication.
Where is that report? That's the report dated?
This is, my lord, report dated 17. Direction.
Cannot be 17 because order itself is of
4/9/2025.
My lord, 4/9/2025. In response to that,
17/9/25.
yes.
Now, which doctor has said that he is mentally normal?
My lord, Dr. Paripada Medical College.
What is the qualification of the doctor who gave the certificate? Is he a psychiatrist?
Department of Psychiatrist, my lord. Professor Psychiatrist.
Where is that? You have not filed anything. The last order was the report taken this report. What do you say? If that is the ground, then that ground is no more available.
In that situation, my lord, let the matter be placed for hearing, my lord.
This proposition, in view of the report dated, what is the date of this report? 4/9. No. 4/9. 4/9/2025 by the Assistant Professor, Department of Psychiatry, so the learned counsel for the petitioner, the convict appellants submit that the matter may be heard finally. Appeal may be heard finally. Leave the matter for final disposal on submission.
Yes. Item 31.
May please announce. Until please answer some money, then you take up things after me.
Item 32.
My lord. My lord, here, the last occasion also.
32, my lord.
Custody certificate and the conduct
antecedent that I have given.
Yes.
Custody certificate, criminal antecedent.
Yes, yes.
Jail conduct.
Cause of death was an accident. How can the doctor will say this is homicidal death or accidental death? Cause of death was an accident.
Vehicular accident.
Vehicular accident.
Pursuant to the order dated 29/11/2025, a report has been report by the district jail authority has been placed on record. The report indicates that the petitioner's jail conduct is satisfactory and he has no criminal activities. He has not committed any criminal activities during the jail custody. The convict petitioner is in custody since last 3 years, 7 months and 16 days. 16 days. Please the application for application for hearing on the next week. And on 2/12/2025. Custody.
2/5.
More than 3.5. Okay. Next week.
Published.
Item 33.
In this case, the petitioner challenges the improved order of Annex 30, page 18, challenging the order of the learned tribunal, where the contribution has been dropped. The ground that there is no vacancy of driver. The sole grievance of the petitioner is the compliance of the order under Annex 4. And can go to page 15. Next 4, page 15. Sorry, Annex 5, page 15.
Against dropping of the proceedings, contempt proceedings by the learned single judge. Is it appealable? Whether the intra-court appeal lies? No. What is this? WP it is. Yes. Number 33. It is number 33. What is your grievance in the petition?
This petition is to comply the order of this Honorable Learned Tribunal under Annex 5, where the direction is to give appointment. But they are not giving appointment to the post of driver on the ground that there is no vehicle is there.
No vacancy.
No vehicle is there.
No
vacancy is there. No vacancy is there.
No,
whether for
there is
giving
no vehicle is there.
No vacancies are there, the lordship line.
Yes, no availability of vehicle is one thing. Availability of vacancy
Vacancy is another thing.
What is that?
There are, my lord, but total vacancy is of the
once
To 1970. See section 19.
Confirmation, whether the applicant can be appointed against any unreserved vacancy at his disposal. It will not say 50. In order for bunnies to be effect, then appeal. It's not on topic. The structure of the operative portion of the order. OA is disposed on. Kindly come to page 15, 1
Madam, page 15.
Yes, read
This OA is disposed of with the direction to the collector Sambalpur to ascertain from the CDMO whether the object.
Slowly. There are too many directions in that. First one is to whether the applicant can be appointed against any unreserved vacancy at his disposal. Okay? Ascertain the vacancy position. Then CDMC will give a clear reply to the collector within 1 month. So and so. Then in case he cannot be appointed by the CDMC, then he may be adjusted in some vacancy at the disposal of the collector, available or anticipated, which is earmarked for the general category of which it is permissible to fill. Observing the imposed basis, it is expected that it would be to adjust in some portion, either under exercise of the. Yes, what is the exercise done in terms of this order? Show us. On what basis you say that vacancy is not available?
My Lordship, may kindly have a look for the.
Where have you ascertained and from whom you have ascertained the vacancy position?
The counter affidavit was filed in this case.
Now let us understand. What is the order according to you?
My Lord, order is twofold, my Lord. First one is to give him appointment ascertaining the general category. I am coming to that. 15. It is twofold, my Lord. First to ascertain the vacancy.
First part.
First part.
Go to the last part now.
Last part is it is expected that it would be possible to adjust him in some post either under the collector or under the CDMO within 4 months from the date of receipt of a copy of this order. My Lord, the vacancy was 6 only. The advertised vacancy was only 6. From out of 6, my Lord, your Lordship may kindly have a look to the report, which is annexed to the counter, my Lord, B/1. Detailed report.
Let us understand the order first. The order of the operative portion of the order,
my Lord,
has to be understood with common parlance, common sense.
My Lord.
So come to the last part.
My Lord.
We'll assume that first and second part, perhaps we are entitled to argue, entitled to take some refuge.
It is
expected
that
it would be
possible to adjust him in some post either under the collector or under CDMO within 4 months from the date of receipt of a copy of this order.
Is it a standalone direction or it is coupled with other directions?
No, it is an independent step.
Independent. Therefore, you need not go back to the other part at all.
Other parts, my Lord. My Lord, collector and CDMO, in both, collector is the appointing authority.
That's what but why these things are dangerous? See, the expectation is not a direction.
It is not a direction, yes.
The fact of the case is that a merit list has been prepared by a rigorous interview for the post of driver. The petitioner was selected and petitioner's name was sponsored to the next to page 9. Assistant Town Planning Unit for give appointment.
The question is not when order is clear.
Sir,
we need not travel to the pleadings at all that resulted into that order. The Supreme Court says, in interpreting the order of the court, if there is any doubt As an exception, you go back to the pleadings. The order is very clear, crystal clear. Where is the direction? Expectation of a judge is not a direction. You may have expectation, desire, and other things. They are not direction.
They are not directions.
Violation of a direction is a contempt. Not meeting the expectation is not a contempt. We have not developed to that level.
Direction to the collector.
Conduct.
So this is the way disposed of with the direction to the collector. Samurpur to ascertain from the CDMO whether the applicant can be appointed against any unreserved vacancy.
To ascertain.
Sir.
The ascertain is not possible.
No, sir. There is a vacancy, but the collector has not.
That may be give you a fresh cause of action to agitate the issue once again. But can you maintain a
sir.
Contempt petition?
Disposal of contempt application for your lordship.
Sir, my impugned order kindly perused, madam. They admitted that there is a vacancy. Sir, page 18, there is vacancy. But since there is no vehicle, sir, last 4 lines of page 18.
The order.
Sir, the name of the applicant is placed as there, but as 2 posts were available in the general lottery, the case of the applicant was not considered. It is further about that. As against 36 sanction posts from driver, 24 drivers are in position, but as no other government vehicle is available, the collector Sambalpur is not in a position to issue.
Driver positions are there and vehicles are not.
Vehicles, sir. No.
G. Simple reading of English by Wren and Martin grammar. It does not speak of availability of vehicle. It speaks of availability of vehicle. C, vacancy. If vacancy is available, whether there is a vehicle or not, you have to appoint. That is how, though the language of the tribunal may not be that happy.
My lord,
but we have to understand it with common sense.
Then, my lord, as the respondent authorities have filed compliance reports showing impediment for which.
Now, have you purchased the vehicles?
No.
No, we do not know. Post is available.
Post is not available, my lord.
That is the findings. Just see, the impugned order also says that. Yes. Further award by you that 36 posts were available, to 24 posts are vacant, filled up, and other posts are not filled up because vehicles are not there.
12 remain. You buy vehicle.
Buy vehicle.
Let me get instruction then from the collector whether vehicles are there. But here only vacancies are 6 at the time of recruitment. Only 6.
This is recorded from your pleadings.
24 plus 12. That comes to arithmetically 36. Going by simple arithmetic.
No, it is what
you saw the compliance affidavit which you have filed in the contempt.
It is not there with me now.
Do you have the copy? Compliance affidavit.
It is not there with me now.
Because this recording is from compliance affidavit.
Number 1. Number 2, very loosely the operative portion of the order is structured. As if some essay is being written by the tribunal. People come here for getting the orders, not sermons.
You have the copy?
Compliance
affidavit.
Even otherwise you have stated 36 vacancy, 24 filled up.
No, my lord,
12 remain unfilled.
My lord, the recruitment to the post for which he has applied for in the advertisement was made for 6 posts only.
Very well. Even otherwise, kindly read the last part.
My lord, lordship,
last part of the operative portion, Mr. G.
Why have you not challenged that order then? You have challenged that order.
Lordship, annexure BY1, your lordship may kindly see. Findings of the selection committee meeting. Lordship may come to that. Affidavit I had filed by BY1, your lordship may kindly see.
You tell us one thing. Do you have any grievance against the order dated 5/9/2002 passed by the tribunal?
5/9/2000.
The original order.
No, we have not.
You have accepted it. You have accepted it. Then today you can't go back and argue the matter afresh. Now see the operating part. Comply the order. That's what. As simple as that.
Let me, lordship may call this matter next week or
And
2002 matter.
It is in
struggling for
2000,
bond maintenance.
advertisement was made in the year
2020.
Advertisement was
2020.
advertisement was also made long back.
This petition has suffered so many other protests.
3-4.
2022.
Compliance अच्छी कौन? Compliance नहीं. Copy does not do.
See, Mr. So-and-so, learned additional standing counsel is directed to take instruction as to whether petitioner can be adjusted in any other group D posts available with the opposite parties authority or not.
Do you have any instruction?
No, I have not.
2024.
I'll get that. I'll get
That
that.
instruction, they have held that group two posts are already been abolished by.
Merge with group C.
Sorry,
Merge with group C.
Drivers are group C posts.
Group C.
No, the next order says group D.
Group D post.
As a matter of concession, that very sorry that our courts are treating the contempt proceedings as if insignificant. It cannot be. The order said group C.
I will get that all the.
Group C.
That
That's
is
also.
group D.
Yes, I'll come with all the instructions.
See, this matter has suffered
Too many years.
Since
Too
long,
many years.
since long, my lord.
years.
It was a recruitment of the year 99, not 2001.
So come tomorrow.
Tomorrow,
Tomorrow
it's
is in, sir.
2 to 3 days may be given for that. I'll get all the.
Friday. Come with. Right.
Monday, my lord.
No. Friday.
Friday.
Friday, yes, what, yes, sir.
Lordship.
Yes.
Item 36.
Sorry, my lord. Item number 35. In this matter, this read petition became infructuous. The reason being, the DRT Cuttack has disposed of the read petition.
Petition.
Sorry. I mean,
Dear OA.
Yes,
OA is disposed.
Sir, I am not. Application was
Nothing remains.
Starting to notice
Who appears for the petitioner?
petitioner.
We will record with liberty to recall in the event your submission is not.
Yes, this is the job.
Submission prayer reads silent. You are for bank.
I am for the
Borrower. This petition has been filed.
changing sides. Occasionally.
My lord, petition has been filed to implement the order of the district magistrate under section 14. The essay has been allowed, 13 to notice has
But
been.
they are saying it is adjourned week after next.
My lord.
Let it come because the jurisdiction.
Pressure नहीं, time नहीं पड़े जाए.
Item 37.
This is actually beautiful. After will report to the mediation. Then the mediation report to that flat fee.
What happened?
Paid.
What happened? Is it a successful mediation or no? Mediation.
Yes.
Your Lordship may say the order dated 7/8/2025. As per this said order, it has been sent to the mediation.
But mediation did not fructify.
They are
argue on merits.
They have filed the counter affidavit. On that date, I have received the copy and this court has referred to mediation. I may be permitted to file my rejoinder to the
Rejoinder to counter. Next week you will do that. Week after next. Week after next. It is 5 minutes. Yes.
Item 37.
May I please?
Yes.
I am for the opposite party, madam. The department has approached this court against the order of London Central Administrative Tribunal. So far as the promotion is granted, as per that order, from Deputy Commissioner to Additional Commissioner of Central Excise and Customs Department. That order which is passed by the London Central Tribunal at paragraph 6 have clearly mentioned all the facts. Can I please before my
No, just tell, then go further. Just what happened then? Whose petition it is? It's my petition. He should argue. Yeah.
In fact, I was seeking for adjournment the first for the reason that
Learned DSJ would have more eloquently pressed the matter. I'm not giving more time. Any day, Monday or Friday, if Lordship takes up the matter, the only point is whether Harsh Kumar's judgment can be relied upon or not. It is not covered.
You are not lacking eloquently.
Lordship more eloquent. In fact, this Honorable Court is only directed to decide the matter in view of Harsh Kumar's judgment. It has been decided that is to be placed. I only play any day, Monday or Friday, if at all, Lordship, because DSJ is for bereavement, is out of station. That's why I pray for Monday or Friday, any day, Your Lordship pleases.
You can simply say whether he is covered by the judgment or not.
No, it is not. It is not. The order has been passed, that has been challenged before the tribunal, and tribunal has agreed that it is covered, which we have challenged before this Honorable High Court. So that is to be apprised. I prepared a date chart also as well, Lordship. Any day, Monday or Friday, at least, Lordship.
It is covered by your Lordship judgment.
Let us see. You will argue. Take the request. Take the judgment.
Lordship.
Just take the judgment.
I'll verify. If it is covered, then it's
very first as it Jaman or Miss Ponda.
Yes.
Ashok Ponda, your Lordship keep pass now. In similar footing. So unless it is not Friday.
I am for the respondent.
Counsel for the petitioner is absent. Call of 2 weeks. Yes.
Item 39. And this is a case for pension that the petitioner was a Kendriya Vidyalaya Sangathan under Kendriya Vidyalaya Sangathan serving as a teacher, and there is impugned order to Central Administrative Tribunal stated, my lord, that's only original application there and one common order, everything is disposed of. And that is starting from page 66 is the.
What is the order of the tribunal? What are the defects which warrant our interference?
Tribunal disposed of these all 5 to 6 original applications, thinking under impression that the petitioner has exercised his option not to come to the pension scheme. Well, the fact of the case is that KB was not under pension scheme. Under 4th Pay Commission, KB was added as a pension scheme. So that's a central government of resolution. Those are working on 1186. My lord, that I draw Lordship's kind attention to that, my lord. Annexure 1, page 12, my lord. They're all
office memorandum.
Yes. My lord, there is everybody who are on CPF beneficiaries, that is Contributory Provident Fund Scheme. After 4th Pay Commission, they are all serving KV teachers, teaching staff, non-teaching staff.
They came under pension scheme. Go to next point. Yes.
My lord, all CPF beneficiaries, my lord, paragraph 3, who were in service on 1186.
Where are you reading now?
Page 12, paragraph 3. My lord, this is all CPF beneficiaries who are in service on 1186 and who are still in service on the date of issue of these orders will be deemed to have come over to the pension scheme. So I was serving at that point of time, I was 82 entry and I retired in 2018. So under this clause, I must be covered by the pension scheme. But Lord and Tribunal, my lord, dismissed that.
The tribunal has noticed this circular?
Yes, they have totally extracted in the order, my lord. Office memorandum.
Provided you exercise option.
No,
or without option.
Without option.
Whoever does not exercise option, automatically he is loaded to pension
scheme. But their point, KB has taken a stand, till my retirement, there was a deduction towards CPF. So I have, even if I have not opted for pension scheme, I have exercised the option to continue under CPF.
Para 16, page 63.
My lord.
Page 63, para 16. Reasonings.
My lord.
Read it out. The option to remain in the CPF scheme as admitted by her. Where is it admitted? It is admitted because you agreed for deduction being made, and accordingly deductions have been made for years till the retirement.
I am never agreed because we are in the Andaman and different places of the country.
That's all. That agreement need not be so much explicit. That agreement can be inferred by your conduct in as much as you did not raise any objection to the deduction being made towards CPF.
That is
that way.
That is the whole point. My lord, in the recent judgment, Supreme Court says even if there is a deduction, that cannot be treated that he is agreed for the option has been given and he is agreed to continue under CPF, which is more beneficial to the employee that may be given to the employees. My lord, that is in Utkal in Delhi University versus it will appear in your lordship's screen. Delhi University versus Sasi Kiran, my lord.
How that, whether that judgment was cited before the tribunals? Whether tribunal considered that aspect of the matter? No.
Tribunal,
considered. No. Tribunal
rejected. Dealt with this.
Jayaprakash considered. Even Jayaprakash
Mishra and also Sasikanth case considered but rejected. Only Jaspal Kaur versus Kendriya Vidyalaya Sangathan case is squarely covered to the present case where secondary documents, as your lordship now pointed out, all the secondary documents prove that till 33 years he is continuing, all the petition is continuing as a
till the retirement.
Till after retirement also got all the benefits on the CPF and after
thereafter
5 years exactly. After the representation filed in 2018, retired on 2016.
When retired?
Retired, that is the case.
The
present petitioner, that is I have clearly mentioned my count or my counter page. Running page, my lord, kindly have a glance my counter.
All that we don't need. We need a date.
That date, ma'am. I'm submitting that date. And he has retired
in 2016.
You have to give the date. There is no such culture of giving the date. Every day I am telling this to the boss.
The supervision 29th to 2016.
There is a date chart you have filed. Refer to date chart. Why are you searching here and there? 29 to.
29, that is 29
February
2016.
In the leap year he retired.
Retired on superannuation and also received all the CPF benefits and enjoyed that.
When the OA was filed?
OA filed in 2021 after 5 years of retirement. And after 2 years of he has filed one representation, that is the vital. What he has mentioned is representation which was taken by the tribunal under unnecessary A/3. Kind of lens to the way.
The representation was filed in
2018, and what stand he has taken, that is the dealt by the KVS, Jaspal Kaur and KVS. Once you are a senior class 2 officers, you are mentioning that several representations I have filed to conversion from CPF to GPF, but you have not given a single proof acknowledgement through the competent authority. That was the deal by the KVS matter.
The representation dated. Not next year. It means month and year.
That is
2018.
Once you have filed the speedy post received here, that the your lordship right to 3/10/2018 we filed the representation to convert from CPF to GPF, and in the what he has mentioned, myself Ajit Kumar Singh Babu joined KVS on 16/11/1981 and retired from KVS Baleswar on 29/2/2016 as librarian. My date was such and such. That I had opted for CPF and had requested KVS for change of CPF to GPF benefit plan.
Understood.
But in several times, but no.
Madam, 2006 retired. 2016, sorry. And 2018 representation given, saying that I had been giving unilateral representation. There is no proof of representation.
And second para, he has said that this is the beneficiary. He himself mentioned this is beneficiary.
Our question is to madam. Are you madam?
Breathe.
When have you become madam? You are man. Friendly be. See.
Breathe.
I have forgotten your sister is advising you. Please sit down.
First time it is never been given. This is the representation. Disclosure. They have never acknowledged our representation. That's why this representation given and we obtain an order to dispose of that representation. That is the attitude of the authorities, my lord. They never acted upon the representation unless or until this honorable court or any court has directed them to do it.
Friendly read your representation.
My lord. Myself.
Page 19.
My lord.
Yes.
Myself, Ajit Kumar
Right,
Singh
so-
Babu, joined KVS on 81, retired from KV Baleswar on 16 as librarian. My date of birth is such that I had opted for CPF and had
You have opted for CPF.
that's
Once you have opted, they are all irrevocable options. Apex Court said in 2007. These options are irrevocable because the financial policy, fiscal policy of the central government will depend upon how many have opted for pension, how many have opted for CPF. It's a major issue. Therefore, there is admission on your part that you have opted for. Had you not opted, then automatically you would have been shifted to pension scheme in terms of that the OEM dated 1/5/1987.
That's I'm clarifying. I have never opted for CPF. They have given me the
You have admitted.
Yeah, no, that is the representation. I'm coming to that. I'm clarifying. They have on my retirement. They have given me impression that you have opted for CPF, and that's why you will never be considered.
No, you only have stated.
That's why I have given Annexure 4. Why not kindly say Annexure 4 that RTI document?
How you are going overcoming that admission?
That is not the admission. That is as per my knowledge. My knowledge may be not on.
You have been contributing till you are retired.
Retired. And
Okay.
they are
Opted and contributed.
Correct.
And availed the
retirement notice. They have stated you have opted for CPF. That I have reproduced. But that's why, my lord, I have annexed it. Apart from it, I will come to my good grounds. Annexure 4, my lord, kindly says page 20. Page 20, my lord, kindly have a glance. Because they are teachers, they don't know anything that what will
They are
be
teachers. They are not some real person.
He's a librarian.
What else is necessary? Whole library is at his command.
That's why he does not know that what will be the repercussion of a word. My lord, Annexure 4, my lord, kindly see page 20. That is the RTI document. No such observed from pertaining to period such and such in respect of the appellant, that is the Ajit Kumar Singh Babu, ex-librarian of KV Baleswar, is available in his service record of personal file. He has never opted.
page 3. Deemed option because it was a account number was allotted to you. You have contributed
this year.
That column 3.
But even in that is exactly a case, that is batch case before different high courts. Now I am citing one case before Jharkhand High Court, which has been confirmed by the Honorable Apex Court, that is in the rejoinder. My lord, kindly see page 161, the judgment of the Jharkhand High Court, and it was been confirmed by the Supreme Court. Exactly on the point that even if somebody opted and thereafter wanted to come over the pension scheme, that may be allowed in
When he adopted and when he sought change in that Jharkhand case.
That is, my lord, similarly like the petitioner, my lord.
You that
My lord.
this.
That is there. See, all are retired employees.
Only this question is separated.
Yes. The original referred to working PGT in chemistry Kendra Vidyalaya, and after joined sometime 80. He's joined in the 80, and this case has filed before the 2019.
No, we are asking you
My
when he retired, when he opted. In that case.
My lord. And that is there in the when he has opted.
It depends upon them.
My lord. The fact is,
Can you please show us one representation, except page 19, that you had ever given?
my lord, that in your lordship.
One representation.
So to your lordship, 159, my lord. Lord Counsel for the petitioner further relied that last pay certificate dated 12, wherein also the contribution to the CPF account has been shown. Tribunal allowed, then Jharkhand High Court. So up till 2012, he was under CPF. Petitioner.
Where from we will get that?
159, from the judgment I am reading, my lord. That I have annexed in my counter.
159.
Page 159, paragraph from bottom to fourth paragraph, one line. And the last line in para is further ground has taken that the employee has not opted for conversion from CPF to GPF, pension scheme, but this fact has not been appreciated by the Lorraine Tribunal.
But here it has been appreciated.
In this case, but same fact is same, my lord.
No.
Now, my lord, that paragraph, my lord, 161, I am reading paragraph.
Dismissed on the following grounds.
My lord, paragraph.
There is admission on the part of the petitioner in her representation. There is nothing. This is a repetition.
This judgment.
I will refer to that.
Paragraph, my lord. Kindly see paragraph. That is the High Court are allowed. Similar issue held for consideration before Honorable Apex Court in University of Delhi versus Sasi Kiran and others. So that is before your lordship's screen. 2002 Supreme Court Online A594. The Honorable Apex Court, while considering the issue about the effect if the employee has not furnished in option, in considering the issue about the effect if the employee has not furnished the option in pursuance to the option sought to be furnished by virtue of the order dated 13/4/87 followed by DOPT letter dated 87 and in absence of any opinion, but only because the subscription has been made in the CPF account from the salary of one of the other employee, which has been considered by Delhi High Court in case of R.N. Birmani and other batch of cases, wherein the appeal preferred by the employer university has been dismissed by declining to interfere with the order.
That is option not sought for.
Yes, here they have sought for option, my lord. We have never given option. But when you have, because my lord,
Kindly, you have argued. This is a written concern under 227. You cannot go on arguing till the cows come back. That is not the law.
My lord,
You are in 227.
Yes.
Please understand this.
My lord, just for your lordship, if I am not convinced, then I
We are not convinced because you can't go on arguing the matter till cattle come back. There are many people sitting in the courthouse.
My lord, let me the whole para, my lord, let me say that whole para that this. My
No,
lord,
you have admitted in your representation that option has been given.
my lord, even if admission one can come over, that is the judgment.
After how many years? Read the section 19 of the Administrative Tribunal. 21.
That is para 20. That is my lord, Honorable Apex Court stated.
When court requests you, otherwise you have to order you. Which one you prefer? Court is requesting you to read section 21 of the Administrative Tribunal Act. Read that.
My lord, that is because when
Read.
my lord, when representation disposed of, thereafter they have rejected my claim, then only I can approach. I cannot approach directly.
No, that is not the point. The point is where the limitation is 1 year. 1 year.
After rejection?
No, not like that.
No, you can't keep on giving universal representation.
Your representation repeatedly given would not keep your cause of action alive.
Yes.
Therefore, they rejected it just before 1 year is no answer to that. It is covered by the judgment. That aspect is also covered by the judgment. You cannot go on arguing. Madam, wherever there is
clear before your lordship. My lord, para 20, for a moment, my lord, Apex Court judgment. Para 20. According to the notification dated 1/5/87, 260.
You don't want to read section 21.
Yes, I know, my lord. But this will come. I have approached the tribunal after my retirement. Thereafter, they rejected it. Then I can come. I will not Bihar.
Shall we record the submission that you don't want to read?
Yes, no.
Read that.
I will.
Don't quarrel with the judges. That will not help you.
Wait.
You may lose this case, but you may lose other cases also. Don't antagonize the court that way. We are warning you. Just read it.
Yes.
You don't bring the you don't have. Also, you cannot go on arguing these things. Read it.
Limitation.
Yeah.
Tribunal shall not admit an application in a case where a final order such as mentioned in clause A of the subsection 2, section 20 has been made in connection with the grievance unless the application is made within 1 year from the date on which such final order has been made.
Then go to next one.
In case where an appeal or representation such as mentioned in clause B of subsection 2 of section 20 has been made and a period of 6 months had expired, thereafter without such final order
You cannot
having been
proceed
made.
Therefore, suppose you make an application, representation. After 10 years, the representation is rejected. You mean to say that the question of limitation will begin from that order? Then the second part of this section will commit suicide, if we agree with your contention.
And
one representation you have
limit an application.
No, one representation you have given.
And passed an impugned order. So this 21 limitation will not cover this case because it is already admitted, counter rejoinder filed, adjudicated. Then I am before your lordship challenging the impugned order. So the limitation point has never been dealt by the tribunal or anybody, my lord. Limitation
Therefore,
is not a case before the tribunal.
But we are bound to read section 3 of the Limitation Act. Read section 3. The court shall dismiss a cause that is brought before the court with the delay, whether the issue of delay is raised or not. Read section 3 of the Limitation Act.
Your lordship, my impugned order, which before it is never speaks about the limitation. Why is it not?
It need not. Court can look into that because it is a parliamentary mandate.
Your lordship, certiorari jurisdiction, my lord, that whether this is as per the law governing the field or not, that is to be, my lord, seen.
Your first point is your client has not opted at all.
No,
Yes.
not
First
that.
point is
My lord,
petitioner has not opted.
after that, and considering that judgment that Supreme Court exercised, the second situation where a conscious option were exercised, my lord, that honorable Supreme Court judgment, thereafter batch of cases filed in different high courts and principal bench, everybody that is allowed. My lord, the second situation being where a conscious option was exercised before the cut-off date to continue to be under CPF, R.N. Birmani batch of cases was therefore rightly allowed by the learned single judge and the division bench of the High Court as no conscious option was exercised by the cut-off date. Consequently, the
here you have exercised.
No, I am not exercising.
You have admitted in your representation.
Even if exercise, my lord. But I abide by my line that I have exercised. Even if exercised, if GPF scheme has introduced and they are continuing under the service, they have to come over the pension scheme. That is the judgment, my lord. I will come prepared some other day.
No, we don't do on installment rate. We don't do our job on installment rate. I was expecting the same thing just before some time.
Friday, my lord. I will come back by Friday. Just to convince your lordship.
To follow. Yes.
My lord, just convince your lordship. Friday, my lord. It's a pension.
You can't dictate to the judge, but judge can dictate to your
You
can't dictate to the judge.
This bench cannot do such a hard thing.
What hard thing we have done? Wherever there is justice, we have always given in your matters. In 13 matters of yours, you may not remember. I remember because I have data. In 13 matters, I have granted relief to you when I was sitting on the single side. Don't say that. These are all advocacy skills that you must help me. Dismissed. Next. Next matter.
Pardon, my lord, item 38, my lord.
Next matter.
My lord, item 38, my lord, I was...
Reasons to follow. We have 5 days to give reasons.
If you are really, you can file a written note.
My lord, pardon.
Court has given 5 days for us to give a reason.
That option maybe I may exercise before your lordship.
This is kind of pressurizing the court.
I'm not with that.
You are still sufficient.
You are lordship 13 times. You are accusing me with somebody.
No, you have appeared and I have taught. You may not remember. Unfortunately, I remember.
Every day.
No, the problem is when you take relief, you don't remember.
And when a matter matter is listed before your lordship.
Madam, you have argued very appreciate you. We will say one paragraph will be dedicated to your performance. Don't pressurize the court. That will spoil.
Forward is the court, she can't go. I can't know where I can't. This is the last court of the.
Another court is there.
Madam, item 30.
Yes.
Just I entered my lord, 38 my lord, that is the pension matter that I have come before my judge. 38.
38.
38.
Not you. 38. 38 is urgent. It is urgent.
Urgent matter is a pension holder my lord.
The other side has gone already. Brother, if you are very serious, you should be here at 8:29 to oppose adjournment matter. How can we know? If we do not give adjournment, you will be angry. If we give adjournment, the other side will be angry. It is nothing but sandwiching the judges.
No, sir. Sorry, my lord.
Next week, go on doing
Next week, my lord.
whatever is order we have already signed. Look into that. Yes.
Item 40.
May I take the lordship? The lordship just have a glance to order dated 4/8/2025, that is order number 3. That is, my case is squarely covered by the case of Union of India versus Naveen Kumar Senapati. For that reason, your lordship passed order to the counsel for the opposite party.
You are supposed to verify.
And in the meantime, another
Who appears for the Union of
Union of India, your lordship.
What is not? Covered?
No, not covered in that.
Not covered.
Not covered so far as my limited knowledge is concerned.
Not for as per your knowledge. Whether it is covered or not.
And you have anything objective limited also.
And in
Let me verify this.
You have seen this order was passed in August 2025.
August 25.
And you are not able to, we will just see
I have
whether it
given
covered or
a
not.
copy, your lordship. Sorry for interrupting. I have also handed over one copy. On that day, 3 days.
Talking to him, na? We are speaking to him.
Sorry, my lord.
Naveen Kumar Senapati.
Brother, on 4/8/2025, the coordinate bench has made an order.
My lord, I am not disputing. This order must have been given to some other standing council.
No, we don't know.
That is not
who are
available to me. That is why I am saying.
No, that makes no sense. How many council will change, government will change is not our business. They don't consult us.
See, Mr. Gochai,
There is an order.
Hemant Rai, you appeared.
Now, how can judges go on changing which matter is interested to whom?
On merit, my lord, I do not know whether this is covering under this actual aspect or not. On merit, my lord, it doesn't have a case. I mean,
next week you will come and say.
And in the meantime, another judgment has been passed by my lord along with my lord Justice.
That is covered under that policy. Then I will say that I
see this and add this.
My lord, that is. Your lord, handing over these two judges.
Call this reluctantly. This court, the coordinate bench, white order dated 4/8/2025, had said that first, since then, 5 months are over, and learned CGC, your CGC, learned CGC submits that he is yet to examine them in the light of decision of the apex courts. In UOI versus Naveen Kumar Senapati and another coordinate bench decision in WPC 37387 of 2020 between Gauranga Jena versus UOI, disposed of on 4/8/2025. First one. Next one, in the above circumstances, very reluctantly, matter is adjourned by 1 week. Finally, first one.
Your lordship may keep it also record. I have extra.
Item 41 has been adjourned. Item 42.
No. Notice was issued. Your lordship was pleased to issue notice by order dated my lord 15/10/2025.
Yes.
And
in this matter, I have instructions to appear for the opposite part number 1.
Yes.
I seek for 4 weeks time to file my counter, and in the meantime, I will file my Vakalatnam also.
On 15/10/2025, notice was issued to you. You are the sole respondent. You are the sole respondent. When did you receive the notice? Under your Orissa rules, so what is the time for filing the objections? Filing the counter? What is the time limit? They are asking you, if you stand like Rock of Gibraltar, with all muteness,
As per the
then what
notice,
judges should do?
as per the notice, I should have filed my objection by November. The date is given. That is.
Nobody is following the timeline prescribed by your rules, our High Court rules.
12th November was the date.
All right, call week of next at the request of and consult of the OP, call OP, who seeks to file counter. First time, if counter is not filed, in the meanwhile, come on. Right to file one stands forfeited and petition averments may be taken up with the face value. Okay. 2 weeks.
Item 43.
Public.
English. Yeah.
My lord.
You, who is the other side? You are the other side?
Yes, ma'am.
Okay. Ready in the matter?
I have not yet filed the counter. I pray.
When
2 weeks time.
15,925 was the order. Then follow up the 2 weeks at the request of. No, somebody should conduct the cases with all seriousness. That is not happening. And you expect that we should dispose of more matter. How it is possible? Unless you cooperate. Coming here, standing here and taking time and going away. Your clients are not watching you all. Then we will tell your clients to watch the proceedings as to how the performance of the advocates in this court is. They should know how lawyers perform in the courts. Coming, taking adjournment, going without informing the other side. He will come when the matter, he is under impression, matter is being taken up, and we say it is adjourned. What has happened to the bar? Are we not happy with this bench?
Yes, ma'am.
Whatever, then we will not take up your matter. He says he is not happy at all.
No.
Yes.
Why? So your lordship may call it next week. We have filed a counter in the tribunal. That may be an issue.
You don't want to fight. You want to let him fight. Okay.
Item 44.
Yes, sir.
My lord, this case notice was issued on 22/10/2025. Here, my lord, the petitioner challenged.
Who is your opponent?
Union of India.
Union of India. Generally, Union of India is let down. Yes, he is there. I know some came to come out.
It's actually an enforcement directorate. He is the main contesting party.
Who appears for ED?
Separate panel counsels are there.
There are panel advocates are there.
Yes.
In case the Union of India was there.
No, Union of India is there. The Revenue Ministry of Revenue.
No, that
number 2 is the enforcement directorate. ED has got a panel counsel 2 and 3.
Cat, my lords. Union of no ED council is there. The Union of India.
No, in High Court they have ED counsel, the panel counsel.
No, there are panel counsel.
There are panel advocates. Who appears? Mr. Agarwal.
Mr.
Shri Gopal Agarwal, senior panel counsel, is requested to accept the counsel. You take notice for OP2. What is the service position? With the legislative third. They are.
My lord, they
already been.
Pursuant to your lordship's direction, extra official on the Union.
All right. But he says, you take fresh steps again for 2. Petitioner to take fresh steps for service of notice on OP number 2 and 3 within 3 working days.
I'll repeat it's fine.
Yeah, this in 3 days. 1 week. 1 week. Within 1 week. Okay. Next.
Item 45.
Short facts, my lords, are this. I've already prepared a rejoinder.
Yes.
The short facts are telltale, my lords, in this case.
You are a petitioner.
I'm the petitioner, my lords. I am
you are
an option purchaser.
You are ready.
I am an option purchaser.
I have served the copy of the
You have served as a copy of the counter affidavit.
No, question is simple. Are you ready?
I'm not.
Right.
Lakshmi, can I have my list of dates?
Yeah.
On 12/7/2023, an e-auction. I am a, my lords, complete stranger to the loan and everything.
You are not a borrower?
Nothing.
Nor guarantor?
I just, my lords, I just,
Security?
nothing. I am an auction purchaser, plain and simple. 12/7/2023, an e-auction sale notice for the scheduled property was purchased. My list of, Lakshmi, kindly have my list of date at page 2. Page B, appendix 2, page B. On 30/7/2023, the dates are crucial. Files a second appeal, number 137 of 2023 before the DRT Cuttack challenging the auction notice. Borrower files. Then, my lords, on 1/8/2023, the bank appears before the DRT. Order reflects receipt of 15 lakhs from the borrower. Bank has received 15 lakhs rupees from the borrower during the pendency of that essay. On 2/8, I participate in the auction. They have not disclosed to me that they have already started receiving money from the borrower. On 2/8/2023, I participate and I am declared as the highest bidder. On 3/8, the deadline for depositing 25% of the bid amount of the petitioner was there, and I deposit the required bid amount, my lords.
Yeah.
On 14/8, they take the balance amount of 1 crore 10 lakhs from me. On 19/8, the bank issues letter confirming sale of the scheduled property to the petitioner, that is to me. On 22/8, DRT order reflects bank's receipt of an additional 19 lakh rupees from the borrower. An interim order is passed restraining further action. So my lords, the auction goes for a toss. They have given me a sale certificate, but the DRT restrains them from selling. Then, my lords, on 3/10, the bank issued a sale certificate to the petitioner stating that this property is sold free from encumbrances. This is also a certificate which does not disclose the truth because the property was already encumbered by a DRT proceeding.
So you sought for auction, refund of auction money?
I sought for refund. Bank says you go to the DRT.
Unjust enrichment.
Playing fast and loose.
Criminal enrichment.
Fast and loose. How can they?
Conduct of the bank. You auction the property. And you, without making it known to him, you receive money from the borrower. And thereafter, you receive full money of auction price. Thereafter, again, you receive money from the borrower.
You can't receive in both the sources as well as with clarification.
And in the counter, they are saying, my lord, still words, that we have adjusted the bank dues. We have returned the money, balance money to the borrower, original borrower. So we are unable to. You go and take your money. This is, my lords.
Auction purchaser is holding a sale certificate.
What sale certificate? After the after there is an order.
That money with regard to the deposit by the borrower is lying with the DRT. We have not, the bank has not received. That is the DRT order I have.
Did you tell the DRT
that
we have auctioned this property We have received so much money.
Yes, this petitioner is also contesting in the surface application, my lord.
In your, what was your stand,
my lord,
before the DRT?
My lord, my stand before the DRT is, with the due process of law, the property in question has been auctioned. The legality of the sale, since challenged by the borrower before the DRT under SI number 73, for that reason, the DRT prima facie passed an interim order, and that order has not been challenged by the auction purchaser. That has.
Why should
but the bank has issued the sale certificate on the as is varies basis, my lord.
No, you get the money.
Hey, my lord, if unless and until the sale certificate is request, my lord has enormous power. Because the sale certificate has already been granted by the authorized officer to the in favor of the auction purchaser.
See, Mr. Saud, tell us,
my lord,
on 1/8/2023, when 15 lakhs was directed to deposit by the borrower, that day he was not party to the proceeding. Obviously, because auction takes place subsequently.
Yes.
On that day, what is your conduct? You should have said that tomorrow the auction is fixed. Why have you accepted that?
That deposited money by the borrower during the course
you
of.
You have intimated
that money
tomorrow or auction should have been cancelled.
Bank has not received any money. Bank has received money from the auction purchaser.
Very well. Now
we have not received the order. I have annexed, my lord.
Mr. Sahu.
My lord.
He is an auction buyer.
Yes, my lord, he should not be put in trouble because he is either borrower. Yes, sir. But my respectful submission before the lordship, the sale certificate since is there, and that will be quashed, and your lordship will pass an order because
where is the borrower?
Borrower, he is not made a party.
No, you have to make him a party.
I'll make him a party.
You have to make
that is the crux.
Borrower is a necessary party.
No, Lord, I'll implead the borrower.
Petitioner is direct, will direct you to implead a borrower so that you need not file application at all. Petitioner.
I'll do it in court. I'll make a correction.
Directed to implead. The borrower of the subject loan as a OP number 4, 2 OP number 4. Since he is a proper party, if not a necessary party, in the light of apex position in Rajia Begum versus Shahnawaz Begum, AR 1958, SC, so. First, petitioner to amend the cost date. Issue emergent notice to the newly added OP number 4, returnable within 2 weeks.
Great. Then
there's no impediment.
No.
Obliged.
Great.
Yes.
Item 46.
Why will parties doing?
May I please your lordship, madam? I want matter may be taken up tomorrow, my lord.
Tomorrow?
Yes. I'm ready, but some notes are prepared so that it can help my lords, my lord.
Next week you do?
Yes. Small prayer, madam. That I have been appointed as amicus curiae. There are lots of advocates' name is there. That may be.
All right, your name is there.
Yes.
We will see that.
And noting is there only two appellant has died. As per my instruction, appellant number 1.
Tomorrow you are arguing it. Point out those things.
Not that appellant is dead, my lord. That is.
Which all the appellant dead?
No. Noting is that 2 and 6.
2 and 6.
2 and 6.
Yeah,
2 and 6.
The last to be brought on record.
No,
my lord, it is abated, my lord.
Abated.
Sir.
And also 1 is dead, man.
1 is dead. Where is the report?
My lord may see that order dated 12/8/1920.
19?
10/20.
20.
Yes.
15/7/2025. Abatement.
1920.
Yes.
That Nirakar Bagan is.
For that
Also, appellant number 1.
Yes, Nirakar Pradhan.
Has died. However, there is no mention about the well-being of the whereabout of appellant number 2 to 6. Now, 2, 6.
Only
One died.
2 died, 6 died.
1, 2, and 6.
6. Confirmed only
2, and 6.
Then the remaining is 3, 4, 5.
3, 4, 5. Right on. The record reads appellant number 1, 2, and 6. Of an application under section 394 CRPC, either by the LRF, the deceased appellant, or by the next friend, the appeal, 2, 3, and 6, appellant 2, 3, and 6 stands abated. The appeal is to be the appeal 3, 4, and 5, appellant number 3, 4, and 5 is scheduled for hearing on next week.
Date next week. 98 matter. The father and sons are there, man.
Next
yes,
week?
yes, yes. Oblige.
Item 47.
Legal as concerned, they are also the appellant, man.
They are also
yes, yes.
Entire family.
Dispute, civil dispute. Dispute with the brothers.
Okay.
What to see like 1, 2, 3, and 2, 4, 3, 6, hold.
Yes.
Item 47.
Yes.
47 here man. Just here. 47 Malad has directed to take instruction. So far the death certificate is concerned. That is Jundia Laguri. In the meantime, he has expired.
Who? Appellant number 2.
Yes, ma'am.
Jamadar.
Yes.
A2 has died, huh?
Appellant number 2 died. Appellant number 4 also.
Appellant number 1.
Appellant number 3
is
also
already
died.
abated.
Appellant number 1 and 6, initially it was abated. Thereafter 2 is in custody because of the order of your lordship. He was taken in custody.
Now he died.
No. He is in custody in Kemjar jail. He is dead. Because the report he made when he was appeared virtually before your lordship, he made a statement that he died. So State Council was directed to obtain instructions regarding his death report.
Then this appeal survives
only in respect of
appellant number 2, appellant number 4, 5.
2, 4, 5.
Yeah.
And 3 has died now.
3 has died because he was released on parole and on thereafter because that there is no official statement, but that was a statement made by appellant number 2 before the court on virtually.
You have
so that was.
on 20th November 2025, appellant number 2 appeared before this court to ritual mode and disclosed that appellant number 3 has died. Therefore, this court directed the State Council to verify the authenticity of the information furnished by appellant number 2. Further thereto,
and the last page, last
CIG prison headquarters has placed on record a report dated 8/12/2025 confirming the fact that the appellant number 3 has died on when he has died.
Last page, it has been appended to. Last page. Just the reverse, thereafter, both sides. The death certificate,
Date of death.
Date of death is 17/8/2025.
17/3/2025.
death certificate issued by the Jharkhand government, Department of Economy and Statistics, is also enclosed with the report, which is taken on record. In view of the report published by DIG present, the present appellant stands waited in the absence of any application under section 394 CRPC, either by the LR the deceased appellant or by next one. Next part. The present appeal survives for consideration for appellant number 2, 4, and 5. 4 and 5.
Yes, nice. 1 week time may be granted.
Why?
I could prepare and argue the matter.
25 years.
My lordship.
25 years are over now.
No, from my chamber, I was appointed with this matter, so I want to do this.
How many years standing do you have?
4 years.
4 years. Generally, these kind of appeals are to be argued by a counsel who had 10 years of time. This is the judgment of the court. So, last time, yes. Yes.
That honor
Why don't you, as last time, senior counsel appeared.
Mr. Saurabh Chandra Mahaprabhu.
Sir, I just asked, I want to argue the matter, so I have gone through the record.
You assist him.
Okay.
You assist him. Okay. Stakes are maybe. Life is at stake. You assist him. We are not doubting your caliber to argue, but Supreme Court judgment says that at least 10 years standing should be done. Okay.
Anukilal.
Anukilal. Anukilal.
That's Supreme Court judgment. Yes.
Next week. Yes, 49.
Item 49. Well, fixing it to 1 cap.
Next week. 2 weeks after 2
weeks because all the matters has been posted. So other matters.
Yes. (49)
Item 49.
No, please. 2 weeks after.
49.
Who is the amicus curiae here?
Rakesh Kumar Malik.
Let's see. 49 adjourned. Nobody runs. None appears for the appellant. Needs to matter of
Item 50.
That's for your option convenience. Here, the appellant is in custody since more than 16 years. A problem. And just quickly give the dates. Man is in custody for more than 16 years.
16 years.
16 years. Somehow a criminal appeal couldn't be filed. There was some lapses on the of the case. Maybe he couldn't pursue an appeal.
He's still in the
He's still in custody. This court in the earlier order had also asked.
I'll have a class to order.
Premature release is
not possible. Premature release is not possible. That conversion also is not possible.
Okay. Conversion from 302 to 304A and B.
Not possible. I'll just quickly give the dates. The name of the accused we have mentioned in that short note, the hard copy I have given. The name of the deceased is Raimadi Hembra. He was the aunt of the appellant. In Karnataka, my lord, it probably would be Chikkama. Then the date of occurrence is 17/8/2009 at 12 noon. The period of custody is from 17/8/2009 till date. Conviction 302, sentences life. Days we have given, it's based on circumstantial evidence. Now, your lordship knows that there's a judgment of the Honorable Supreme Court where the offense is heinous or the revolting nature of the offense. There, the courts have to be slightly more considerate towards the materials. Now, the nature of case here is very heinous. I do concede that. So that judgment, if your lordship wants, I'll give it straight away. Para 15 of 1994, supplementary to SCC 372. Lordship,
what are the circumstances cited against you? Is it culled out in the judgment?
It is culled out in paragraph 14 of the impugned judgment. But according to me, my humble submission would be that it may not be proper.
No order is made on delay.
Delay was
condoned. It was admitted
for hearing
on 26/11/2025. Last date.
Now, if your lordship wants, I'll show that I have made translated copies of the FIR. If you want, lordship wants, I'll give the FIR copy, the translated version. This judgment, paragraph 15, they say that.
No, let us understand the circumstances cited against you. Page 97, impugn order, para 14.
Paragraph 14.
Take it out, sir. This one. No, impugn order. Yeah. These are the circumstances which has been brought on record against you. EW1.
The prosecution, I'm placing para 14.
Yes.
The prosecution, in order to bring home the charge against the accused, proved the following circumstances.
Yes.
PW1 in his evidence has categorically stated that when he went to the house of the accused, found that his wife was lying dead in his house. 2. The accused committed murder of the deceased, suspecting her to be a witch. 3. PW1 has been cross-examined at length, but nothing has been elicited from his mouth to disbelieve his testimony that the dead body of the deceased was not lying in the house of the accused. No suggestion has been given to him that the dead body of the deceased was not lying in the house of the accused or some other person after committing the murder of the deceased viewed the trunk of the deceased in the house of the accused. PW3, who turned hostile and did not support the prosecution case, in his evidence has stated that when he went to the house of the accused Jyotia, found the wife of the informant was lying dead there, and police recovered a paniki, which was used as a weapon of offense.
Paniki is what?
Paniki, my lords, is
Vegetable cutter. Vegetable cutter.
In Karnataka, it's known as probably Elije Mani. It's used for cutting vegetables.
Ilige Mani.
Sorry, Malaj, I'm not good with that pronunciation. So that is one of the weapons.
Other weapons were also used.
There are two weapons. One is this
whether
money.
Ilige Mani is a weapon.
It is a weapon. Here, alleged weapon is Ilige Mani, and the other one is an axe.
Axe. My professor in criminal law in my college days, referring to Kenny's outlines of criminal law, said, although kitchen knife may be used as a weapon, but it is not a weapon as such. Okay. Yeah, that was the case relating to armed
yes. Yes. Here, this one, my lord, I'll explain what it is. There is one wooden piece, and the other one is the sharp side. So people put their feet on that wooden piece and cut.
Yes.
Meat is also used at time in some places where non-veg is cooked. So it's a sharp cutting weapon. But both are, even an axe. given by the trial court, PW3 has not been suggested that the trunk of the deceased was not lying in the house of the accused, and it is also not the case of the defense that any other person has access to the house of the accused, who might have thrown the dead body in the house of the accused. 6 at page 14 of the paper. PW10 IO in his evidence has stated that about 1 p.m. on the date of occurrence, the accused appeared at the police station holding a bag containing the cut head and admitted to have killed the deceased, suspecting her to be a witch.
He carried
he himself.
Admission to police.
He carried that and had shown it to the police.
He
That
carried.
how he beheaded. It was a case of beheading. Beheading.
He carried it from his house, went to the police station, and told the police that this is what has happened. That's the case. But as we proceed, my lord will see how.
Any mental issue with the accused? No.
Only suspecting that he is under his
not.
and this
was it
evidence.
taken as a extrajudicial confession?
No, there was a judicial confession which that even the trial court has disbelieved. So that judicial confession before a magistrate
Under 164.
Under 164. But in terms of the law, it cannot be accepted. That's my humble submission. Even the impugned judgment says
What
that.
will be the character of this confession before the police carrying the head of
This is not admissible.
This is not admissible.
And that too IO only.
So that's why when I began, I said, my lord, the court records these to be the circumstances, but this
These are
may
not
not be.
circumstances. These are appreciation of evidence, maybe. Circumstances is last thing only.
But the last thing I'll narrate, my lords, if we have to fairly state what the circumstances here would be, one would be that death is homicide.
Yes.
So that nobody can deny.
But who committed it is the question.
Yes.
Is the question. Now, that is one admitted thing. Next would be a recovery of the weapons. That can be a circumstance, but the nature of evidence makes that doubtful. So 27 would be the second important circumstance. Third would be motive.
Which
And his own daughter and sister-in-law had died because of that.
Okay.
That's what he says in his confession.
Okay.
But so these are the three things which your lordships can consider. But then the nature of evidence.
And what about he was found in the same house when it has taken place?
My lords, as your lordship saw, this is the tribal. He walked into the station and said that take the head. I have done it. That's the nature of. These are tribals. In Orissa, there are similar cases where these people walk into the police stations and say that we have done it. But then
there are such cases.
But then if we test it in the legal thing, there is absolutely no material malice, because 27 recovery is absolutely, there's nothing to take it under 27. So the only thing that they have been able to prove is that the death is homicide. That's it.
That's PW1.
PW1, my lords, they have not declared PW1 as hostile. He completely narrates a story which is contrary to the evidence of the eye.
Okay.
So then all that we are left with is the IO's evidence. No other independent evidence.
No, that's all right. So he carried.
The only thing that has been made is 27 because he did give recovery. But that, my lord, in view of the evidence of PW10 and PW1, which I will show in great detail, that 27 recovery itself becomes doubtful. Then another reason why 27 recovery cannot be accepted is that there was blood stain in both these weapons.
No, what is striking for both the parties? See, the FIR was registered subsequent to the disclosure made by the accused.
Yes.
Carrying the head of that body. What will be the character of that disclosure? If FIR is registered, then it is hit by 25 evidence side. But before registration of FIR, if he goes to the police station and says that I have killed this man with the head of that dead body, then what will be the character of that disclosure? Whether it is hit by 25.
No, 25 speaks of admission made by an accused.
That's not police.
And he becomes the accused in the right of that Lalita Kumari.
FIR was not
He becomes accused after the registration of the
FIR
FIR.
was not in existence. So in that situation, what will be the character, what will be the nature of that conviction? It should be an extrajudicial confession.
It is not extrajudicial confession.
Then how will you designate
My lord. And this confession, my lord, because till then he is not accused.
That's
no
what
FIR is registered, my lord.
No, extrajudicial means. This is what Allahabad High Court said, I remember. During this, mine is a very, very frugal knowledge in the criminal law. But still, any confession, any admission of guilt made to any person other than the court under section 164 of erstwhile CRPC shall be extrajudicial confession.
Yes.
This is what Allahabad High Court Justice Dhawan has said like this. That appears to be the correct position. Other than judicial is extrajudicial. Simple. If it is 164, he makes the statement before the magistrate. Other than 164 are all extrajudicial. The question will be, Brother says now, suppose the prohibition is an accused making confession and he becomes the accused after the FIR is registered. So,
that time he was PW10 was not IO.
Yes.
He was not IO.
He became IO subsequently.
Correct.
After registration of FIR when AGU makes the investigation. But merely saying that he is an IO, you can't discount that confession.
Let us read.
When he walked into the police station, he walked into a police station.
Section 20.
It's not that he mistook the IO to be a non-police officer. So the moment he speaks that before...
He went to the police station, then any police officer, forget if he would not have been IO, he would have constable. What would have happened?
No, it is answered with the pre-counsel itself. Any police is as police officer.
You know, if he happens to be IO, if he would have confessed the same thing, he would have done the constable, who is not the investigating officer. So then what would have happened?
No, confession to the police it is.
No, not confession. Confession, it is not to the police. That time if I was not there.
No, if you say it is made to kindly read section 2. Evidence, Ratan Lal Dhiraj Lal on the criminal question. He has quoted one judgment. I read it long ago. Read section 25. 16 or 17 is admission.
My lord.
Admission is 16 or 17. I don't know. Then 25 is confession.
To police officer, not to be proved. No confession made to a police officer shall be proved as against the person accused of any offense.
There were two things are there now. Firstly, he was not an accused because FIR was not registered.
This has to be read along with 26.
Correct. They are cognate provisions. Confession by accused while in custody of police, not to be proved against him. See, 25 is whether he is in custody or not. 26 is custody specific. That is how the text appears. 25 is not custody specific. Whether he is in custody or not. On his own, he takes the head and he keeps it on the table of the police and says, I have beheaded this woman, believing that she has committed witchery.
No, 25, you read it. Now come to 162 CRB, sir. Come to 162 CRB. Who is a police officer? For the purpose of 25. 162 CRB. Yes. Who is a police officer for the purpose of 25? Yes, sir. No statement made by any person to the police officer in the course of an investigation under this chapter. In the course of an investigation, if a statement is made,
That is not.
that is hit by 25.
25.
Investigation has not yet started. FIR was not in existence. Then that statement.
So you mean to say 25, 26 and 162 should be read together?
Now, I got the point, Manoj. What the court is trying to pose is that him walking into the police station and making that statement.
Along with that,
along the
head, beheaded
that was reduced to a station diary entry. Whether this act will fall under the category of any kind of confession, be it extrajudicial or whatever. So that's a point which I have noted it, Manoj. This I think I'll have to research well on this.
That's very interesting point.
But him walking in and giving that thing also is doubtful because of the other evidence. So if your lordships would permit, we can proceed. This I keep it.
Yes.
But other facts your lordship may see, because I'm grateful to your lordship that your lordship has posed this. But there are other points which also maybe even the state may have to answer. Particularly the absence of that chemical examination report. Because we did check the soft version of the TCR and the paper book. It has been sent to the chemical examination report, all the weapons, but the report has not come.
Yes, in many cases, report
it may not come,
and
they could prove the case otherwise.
Otherwise, if the matter can be proved.
Well, look, that's okay. But then in this case, that's a crucial thing. If the report has not come in, then there is nothing to match the weapons with the crime. There's a long line of judgments in that, right? So if your lordship wants, may I place the evidence or? Query. That is something which I'll have to. If your lordship wants, I can give the sequence. He walks in at about 1:30. A station diary entry is made. 1 B Murmu.
1:30 means?
1:30 PM. PM. Daytime.
13:30.
13:30. And then a constable who has not been examined, he is made to watch the appellant and the head. And the police officers go to the spot, which is about 7 kilometers by river and about 40 to 45 kilometers by road. And in that spot, they find PW1. And then PW1 in his deposition says that I was shown the head and also the weapons of offenses.
Who is PW1?
PW1 is the informant and husband of the deceased.
The head was again.
No, not taken by them. So this contradiction is something which has to be. It's a glaring contradiction.
Now, what happened to the head?
Now, the police officer says, PW10, that the accused and the head were in the police station, and a constable who has not been examined was made to watch over it.
And he came himself.
And he came to the spot.
Okay.
To see what has happened. And PW1 says that while I was returning from my field, the police officers came and met me, and they showed me the weapons of offense
as well as the head.
As well as the head. Now, recovery, as per the police, 27 recovery happens post 8:30 PM. Then how could they show the two weapons to the
police,
PW1?
Constable.
No, to PW1, the informant.
My lord, PW1.
So if the deposition is seen,
let him complete.
So my lord, we see the deposition
down so that.
So this deposition, my lord, it's not a very lengthy brief. Just 10 witnesses. Out of that, 4 or 5 are relevant. If your lordship wants, we can may I place PW1 first?
Yes.
So page 32 of the paper book, and TCR page number would be page 42. I hope my lord got the TCR page.
Yes, Doctor, but why PW1 went to the house of the accused?
They are neighbors. Neighbors related also.
He's a chance witness, kind of.
So chance witness, my lord may see, I'll just place the deposition. May I place, my lord? I am the informant in this case. I know the accused Jotia standing in the dock. The occurrence took place more than 1 year back. I sent for grazing cattle and returned at about 4 p.m. When I returned at about 4 p.m. to my house, I found my wife absent in my house. I went to the house of accused Jotia and found that my wife was lying dead in the house of Jotia. I found that the neck of my wife was cut and head was severed and separated from the body. The cut head of my wife was taken away by the accused.
Yes.
Accused murdered my wife, suspecting her to be witch. I lodged the FIR in the PS. Now, cross-examination. This portion is very important, my lords. When I was returning to my home after grazing cattle, the police vehicle stopped me on the way. The police told me that there's no word there, so I presume that this would be that my wife was dead.
Yes.
This line is important. The police told me that my wife was dead. Police showed me a tangia and a poniki. This, my lord, may kindly take note. I'll show PW's 10 in the context of this. Thereafter, I came to the house of Jotia along with the police. The police showed me that my wife was lying dead. Police showed me the cut head of my wife in front of the house of accused Jotia, and I recognized the cut head to be that of my wife.
Where it in the house of accused?
Accused.
But accused had carried the cut head to the police station.
That's what he says.
That's this glaring contradiction is something.
Who has brought it back?
Who has brought it back? And this worst, my lord, is this tangia and poniki being shown to him at between 4 and 8. Then recovery happens, 27 recovery happens at 8:45 p.m. Then how this could be shown to him?
It's not a spot recovery.
No, the recovery
is spot recovery.
If the police recover it on their own without the assistance of the accused, then 27
will not
come.
Are they employing 27?
Yes, unless once 27, here as I said, of course, subject to what fell from your lordships. If the original act of the appellant in walking in the police station is a kind of extrajudicial confession, then that is something which has to, that question I keep it open. But otherwise, how the trial courts has proceeded and the prosecution, even the prosecution doesn't treat the station diary entry as an extrajudicial confession.
Right.
But that's a question from the court. I bow down, I'll answer it.
Well, at this part, we have to see the inquest report.
Then ticket.
That is
his job is to create doubt.
Yes.
And you have to clarify.
Yes.
That's what.
Man.
Let him create the doubt, whatever doubt he wants to create.
No,
that is his job.
Only I don't know, not that.
No, that's the benefit of doubt. You are aiming at benefit of doubt, obviously, and you have to create doubt in the mind of the court.
No,
and he has to clarify that. That's the job.
Because my friend may not know that what point I'm trying to make. So that's why I wanted.
No, just we wanted to have some clarity. If PW1 sees the cut head, severed head, he sees it in the house of accused only.
Yes.
But the option of the prosecution, he has taken it away to the police station.
Yes.
In a bag.
So, my lord, what I'll just quickly do is just 4 lines from here and then straight away go to the IO.
The IO says that the head and the
watch out one
I'll read it short, my lord. I'll only show the relevant portion. Yes. I'll not read the entire portion. Now, this line, my lord, may just take note. Page 33 of the paper book.
Yes.
Police told me, this is important. The police told me that my wife was dead. Police showed me a tangia and a poniki. This line, my lord, may just note. Thereafter, I came to the house of Jotia with police. Police showed me that my wife was lying dead. Police showed me the cut head of my wife. in the house of accused Jotia and I recognize the cut head to be that of my wife.
Yes.
I have not entered into the house of the accused. Many people gathered there. Police brought me to the police station along with axe and paniki and left the cut head in the veranda of Jatia. I have not seen where from the police brought the cut head of my wife. The police scribed the FIR and I affixed my thumb impression. I cannot say what was written in the FIR. These are also contradictions.
No, this is very important sentence.
My lords.
I have not seen where from the police brought the cut head.
Yes.
That means it has gone to the hand of the police.
Yes.
This witness also knows. And somehow it's gone to the hands of the police. And where from police got it, I don't know. It was in the possession of police.
My lord may straight away see ticket. My lord may straight away see the evidence of the police official at page 48. Page 48, that would be
PW10.
PW10, page 50.
Yes.
58 of the paper. 58 of the
Yes, yes, you can proceed with get it straight. Yes.
Now, my lord may kindly see paragraph 1. On 17/8/2009, I was working as OIC so-and-so PS. I received a written report from one Hon'Ble. This my lord may see. Police says that written report was given by the PW1.
Hon'Ble is PW1.
PW1.
Yes.
Husband. Husband says that I have not given it.
Police only had prepared and they asked me to put my thumb and I put the thumb impression.
At the spot and registered so-and-so PS at 17/8/2009 under 302, I investigated into the matter. This is the said written report marked as Exhibit 13 to so-and-so. At about 1:30 p.m., one Jotia Hembram, son of Bikram Hembram, this is the accused, under so-and-so, arrived at police station voluntarily holding one plastic bag and stated that he killed his aunt, Raimani Hembram. On 17/8/2009, at about 12 a.m., as she applied sorcery on his family, for which his daughter Sita Hembram and sister-in-law died being attacked by fever. Further, his wife suffering from fever due to application of such sorcery. After commission of the murder of the chopped head of his aunt, is the plastic bag and surrendered at the PS for his safety. As the oral report of the accused is heinous in nature, with accusation against the report, I reflected the fact in Kuliana station diary entry number so-and-so. The extract copy of SDE of the above fact is in the record. Next line, my lord, is important. On that day, at about 1:45 p.m., I commanded 3/3 B Murbu to guard the chopped head at Kuliana PS, as well as accused Jotia Hembram for further direction. This line, my lord, may kindly take. On that day, I commanded DCH Singh to accompany to inquire SDE so-and-so. Then I contacted SP Mayurbhanj over phone to depute scientific team to village so-and-so to assist me investigation. At about 2 p.m., I along with ASI so-and-so left for village so-and-so to verify the veracity of the truth of the alleged commit. Para 4, my lords, is very important. While inquiring at the spot, the complainant submitted the written report, which was treated as FIR and took up investigation. Then, my lords, I contacted so-and-so for intimated that FIR number will be so-and-so. I examined the complainant and his son, Lemina.
See, the first, when he saw at 1:45 p.m., he asked B Murmu to guard the chopped head.
Yes.
And 2 o'clock he went. After 15 minutes, nothing is coming forth. Whether he has carried that head.
Yes, nothing is coming forth. B Murmu has not been examined.
Murmu is also not examined.
Not examined.
Any explanation offered for not examining?
No, there's no. All the rest of it.
Now, what he does, the subsequent paragraphs would show that he makes a round there, comes back to the police station, arrests the accused who is still there in the police station, and then takes him to recover the weapons of offense. That is paragraph 12 at page 15. Next page.
No, where is that question? How that question? If they are already there in the police station,
my lords,
arresting I can understand, but for recovery,
yes,
which already he himself has produced according to the prosecution.
Yes. So then, in view of paragraph 12,
No, these two weapons.
It was not, that is the doubt he was creating. It is not the spot recovery, 27 recovery.
27 recovery is something which is crucial in these kind of cases. In view of this evidence of the IO and PW1.
This is more circumstantial.
It is only circumstantial
evidence only.
No eyewitness.
No eyewitness.
No eyewitness. It's based on circumstances. In view of para 12 of IO and PW1 who has not been declared hostile.
Mr. Naik, you note it down, whether it is the weapons are spot recovery or 27 recovery. Yes.
If it is a case of spot recovery, then that circumstance goes.
That's right. Correct.
So
they
then,
cannot coexist with each other.
Then we are only left with death being homicidal. And motive, according to me, only the police says. Because PW1 in the later portion says that he had good relations and his entire source of information is police.
That he went for grazing cattle and he was coming at
while coming,
police halted him and told like this.
Yes, and crucial portion, the main damage to the prosecution case is this. Police show him the two weapons there, whereas 27 according to him happens at 8:45 p.m. This contradiction they cannot get over.
That's what I'm saying. It looks like it is a spot recovery. It looks like spot recovery, but they wanted to convert it 27 recovery. Only to bring circumstances against you. Very clearly.
My lords, in fact, since I'm an amicus, I'll tell my lords, what might have happened is, it appears to be a very clean case of confession. They went ahead with the magistrate.
They wanted to cook up for the evidence.
No, my lords. Had they recorded the confession in the proper manner, I have come with all the judgments. Yes. The trial court has not accepted, but then it's a judicial officer. Had that gone through, then that would have been a big piece of evidence. But what they did, that confession, there's a manual, our GRCO, local GRCO here, says what steps have to be taken while recording confession. Here, my lords, the form itself was not available with the judicial officer. One. Second is this person repeatedly, the session.
Form is mandatory.
Yes.
That is a mandatory. For recording a confession of the accused under section 164, that is a mandate.
So the form itself was not available. He has used a separate form. Second major damage there is that both the session judge record as well as the magistrate in his deposition says that he doesn't understand the local language Odia.
Santali and Odia both.
He doesn't understand Odia. He only understands Santali. They use an interpreter, but they have not examined the interpreter. Now that the Kerala High Court in one of the judgments says that if you are relying on an interpreter, you have to either examine it. Otherwise, you cannot rely on this confession. Third major crucial damage to that confession is you have to give him time for full reflection. That has not happened. If at all, the word used by the magistrate, learned magistrate is refreshment. That refreshment happens in the CSI's office. You can't send an accused for reflection before the police. What reflection will happen? So, absolutely, and the learned trial court has rightly rejected the confession. In the impugned judgment, the confession itself has been rejected. So, independently also, there are additional materials to show that this confession can't be looped.
Learned version will be final.
Easy. Learned magistrate, 17th occurrence happens. 18th requisition is made for recording a confession. 19th, the learned magistrate records. Thereafter, the sessions judge, who is the higher up officer, he discards in the course of trial.
He doesn't believe the confession.
He discards it. Why?
Because not proper format is not given.
Whether format is a must, is it? I doubt whether. Suppose if the form is not available.
It may be one of the persuading ground for not believing. But the fact remains that the Kula period is not given and the interpreter is not examined. And the manner in which all these
is absolutely right.
all
All cumulative. So one pointer would be
patients can't be given credence to.
That if that format is there, then the court, it's a kind of an SOP. So he would know that these are the questions.
164 itself doesn't speak about any format.
Yes.
Format is a facilitating way of doing it. Merely because there is no format doesn't mean that 164 goes straight away. Because there is statutory provisions.
But we have got, I think, 60s and 70s, a lot of judgments are there that if you don't record it in the format, then that's good enough to discard.
Discard it.
New kind of judgments. This is not under those TADA and all, the law is different.
No, not like that. Suppose the format itself is not available. If format itself is not available with the court, with the magistrate who records 164 statement, then it cannot be found fault with at all.
We write the proceeding in a particular format, the lining format. Suppose one day while dictating this format is not available, we write a plain paper. Can you say that?
But in that 164 statement, the magistrate at the last part of that statement are given the certificate. That I have
but
explained.
The Sessions Court has not believed
not
and you have to appears to be
you have to give,
That's an additional point.
Because the interpreter is not
27, according to him, 27 goes, confession goes. What remains?
It is a difficult case for the prosecution, but I will.
Now you realize.
Then at the time of reading the file.
How moral conviction?
How law treats?
Not moral conviction, because my lords, the Kyle have visualized the accused who committed the crime and himself went to police station disclosing that he himself committed the crime. The witnesses are also of the same state of mind. They are so innocent, my lord. They cannot.
See, the head was taken by him to the police
along with weapons,
and he was detained there along with the head. And the police comes after 2 o'clock, and he says that I saw the head there.
In one circumstance,
he was carrying the head with him.
My lord, in one circumstance that can be possible, but at the time of inquest, in some time during inquest, the beheaded.
You give the timeline. His very specific timeline: 1:45 and 2 o'clock. This happens within 15 minutes.
What the Bidul once stated that I have recognized the court head of that of my police show me the court head of my wife in front of the house of the accused Jatia.
That is after 2 o'clock.
After 2 o'clock. It can be possible in one circumstance if inquest will be held in the house of the Jatia.
Where is so?
That inquest in paperbook inquest is
inquest.
You want to say
it is there.
No, you want to say that for the purpose of inquest, the head was brought back. That's what you want to say.
That way you should have built up the case. That is not your case.
The inquest report is not in the paperwork. I will permit it to take the.
You take it pen drive.
Yes.
Take it pen drive.
Subject to what my friend says, inquest happens the next day.
Then? Inquest happens in the next day.
The Peter one has not stated at part time.
Ultimately, what happened to that severed head? What happened to that?
Postmortem initially inquest, thereafter postmortem.
So thereafter they handed over to the postmortem might be there. Where is postmortem report?
The body was elsewhere and the severed head was elsewhere, going by prosecution version. First one.
It should be, my lord, soft version, page 82, the actual report.
Exhibit?
Page 82 of the trial court records. Exhibit, I'll just.
Who took the body to the mortuary?
Police. Yes.
Took both the severed head and the body. What is their version?
How the severed head thereafter went back to that spot? That's a
missing. That's that missing point.
It can only be verified from the paper book.
You have
from the TCR.
And it says that PM report says that the average body with head separated from the body. From the neck.
Look, there are additional points. I've just begun. PW3, PW4 have not supported seizure of the weapons. They have turned hostile. Then, my lords, the major issue here.
Admitted the signature.
No, nothing. There's absolutely, in this case, there's absolutely no material. If only on the basis of the IO's evidence you will convict someone, then, my lords, I would not say it. Only the IO's evidence is there. And what I just read out from PW1 and PW10, PW1 has not supported their case. The entire case goes if these two evidences, these paragraphs are compared.
And the trial court has relied upon PW3, who has been turned hostile. Partly, trial court has relied upon PW3. Who is PW3? Is a villager or who is he?
Villager, co-villager.
PW3 just a one-page evidence, page 35 of the paper. Soft version would be page 45.
No, PW3 is very important. Just see, examination in G.
My lords, I know the information.
Police recovered the paniki from the house of Jatia.
My lords.
A spot recovery.
Yes.
Just see. Thereafter he is declared hostile.
My lords.
It is recovered from there.
My lords. And he says that it is not a fact that I have stated to the IO that Jatia, while in police custody, confessed his guilt to have murdered so and so, led to the police discovery of acts and body.
Whether that exhibit A35, he is holding that head and the photograph is taken.
Yes. I've seen those photographs. That's why, Mulaj, I began by showing that 94. 94 Supreme Court says that if it's revolting, then you have to be slightly more. The revolting, if a lordship wants to read a paragraph, at times this revolting, it happens to us also as counsels. The revolting nature of the crime requires a dispassionate inquiry. The exact language I'll just.
That is from the days of pre-concept.
It is to be remembered that in a murder case which is cruel and revolting, it becomes all the more necessary for the court to scrutinize the evidence with more than ordinary care, lest the shocking nature of the crime might induct
blur our logic and judicious mind.
Instinctive.
Whether these photographs are exhibited.
Yes.
Exhibited, yes, exactly.
And the photographer is examined.
Photographer not examined.
Not examined. What kind of investigation? Moderate investigation.
Let's even match the blood stains. Then also there would be something. The blood stains have not been matched.
You see, the photographer was essential to be.
And this man has been addict now. It's 16 years and counting. 16 years he is in custody. And we had that VC in terms of the direction of the court. He also doesn't want, because I had read the file, he doesn't want bail also.
No, he said, because he knows.
So, my lords,
it's very difficult for you, Mr. Naik.
I have put all these
quality of evidence is so poor.
Very, very poor. Even the investigation is not properly done.
The inquest was done, bringing the head.
Not body.
No, body. The body was there in the house of the accused.
Correct. But who carried back?
Yes,
that severed head.
Because in the paper
to the house of the accused, along with the weapons.
Not in detail, my lord. In the paper book. I may permit it.
See, the photographs are very, once you look at it, then it's shocking.
But
those photographs cannot be taken note of unless evidence value. The photographer is examined. Yes, I have taken the photograph. I have seen it. Who knows it is morphed, who knows what.
And if police threaten him to hold the severed head and give poser in photograph, any person will give that. There is a famous statement, give me two intelligent witnesses to me and a lathi. I will see that even a prime minister of the country is convicted. The famous statement of an English judge. In fact, we have to do some observation against the investigating agencies.
And see, the photographs also looks like the accused is very reluctantly standing, holding, see, not.
And the carry bag in which the head was taken, whether the carry bag was marked in the evidence, produced and marked as object, MO. Was it made a material object? That carry bag?
Yes.
It was made. What is that exhibit?
IB.
Huh?
IB. MOIB.
MOIB.
The list of MOs, judgment.
Mostly the police have said, you take back all this to your house, we will come there only. Like this it has happened perhaps. And then when he was coming back at 4 p.m. after grazing the cattle, the police met them on the way and told him, your wife is mother. Then he was taken to the house of accused, where severed head along with the weapons were brought back in the very same bag.
And then
that was shown to him. This is how it appears. It appears that way. Unless, since it's a circumstantial case of circumstantial evidence, unless all links in the chain are perfectly established, we cannot enter sustain conviction. Whether that illegal also contained blood stains?
Yes. The report says that
it contained.
But it was sent to examination. Chemical examination.
Report
has not been. So matching hasn't happened.
Matching hasn't.
And that one judgment we have also got, that unless you match it, then that casts a doubt on the chain. The chain is broken because of that.
Why that chemical examiner, forensic expert did not send examination report?
Very casual manner.
That in fact, we were surprised twice. My associates went to the registry to check and cross-check that how this document has not come. They also, that our internal.
Surprisingly, the
lady is dead, murdered.
The IO says immediately after the head was brought to the police station, he informed it to the superintendent of police. The officer of superintendent of police was involved. Thereafter, this is the nature of investigation. It's not that small.
One more important facet would be that these weapons, that illegal,
more people know
they were kept in the police station for 2 months. That delay also is the blood recovery and all would be
safe custody.
Para 32 the IO says 32 or 31 that I kept it in the station for 2 months without any explanation.
What he had kept? These weapons. But what happened to that body? That body and severed head were sent together for postmortem. On which date they were sent?
Or the day postmortem is there.
Next day or same day?
Not the same day.
Which exhibit is that?
PM report?
PM report, exhibit is page 80. TCR page 82 and 83.
Let us see the date. It is
18th. So 17th is the date of occurrence.
18th. Next day it has been set. Till then they were retained in the house of the accused only.
Yes, that evidence is
maybe in the hospital. Huh? Maybe in the hospital.
No, that is not, nothing is coming.
Inquest has happened on the next day, 18th March.
No, inquest happened means these material objects were in the house of the accused only. Inquest happens in the scene of the crime.
What the IO says in regarding that? The photograph is taken on 17th or 18th?
Inquest twice.
Photograph photograph was taken before the inquest, before the postmortem, or after the postmortem. What is the position?
No, it must be before postmortem only.
Because once the postmortem is undertaken, the figure will be disfigured. So therefore, it has to be done by that evidence is still there. Nobody has spoken.
A preserved investigation.
Inquest, my learned friend is right. The inquest has happened twice. One is
one for the head, another for the trunk.
Head happened on 18/8 at 11:20 a.m. That would be my lord's TCR page 80.
And for the torso,
photograph taken on 7.
Previous day 5 p.m.
Why?
They made 2 inquests.
The head was found in the police station. That was the inquest was conducted on 17. The trunk was
all contradictory.
All contradictory. Whether these police officers are there in the service still? Just ascertain that also. Police officer, and who was the officer in the forensic laboratory? And just ascertain where has he gone? To whom it was given?
Read the inquest report in the middle. It says Murtoro Gondio Kota Mundo Sonjog Kori Ana Porisor Vitoro Uttara Diga Rasta Kodare Vayagala.
That would be TCR page number
89.
80. In our screen, and that is dated 18/8/2009 at 11:20 a.m. on top. That's the next day.
10:50 a.m. 10 capital lecture.
The earlier one is on that is also overwritten.
That is never said.
No, this is
earlier one is next page.
No, before that, just see 89 or something. Another inquest report, another inquest report, reference so and so.
There's another instance.
So, see, another is there. Before that, huh?
It's not 17.
17. Mukti राममणि हेम्ब्रम कटा मुंड गोटे धला प्लास्टिक बैग भितर पाएगला उक्त मुंडटी को बाहर करी साक्षी मानक उपस्थित रे चिन्हट करागला मुक्तिर कटा मुंड को बैग भितर बाहर करी रखिबारे उपरोक्त मुंड र मुह ऊपर को थाई दुई आखि अल्प खोला थाई पाटी अल्प खोला थाई दांत देखा जाउ थाई केश मुकला थाई कानरू रक्त बाहर पायागला मुक्तिर कटा मुंडटी साक्षी मान सामने ओलट पालट कर देखाइबारे मुक्तिर डाहाण पट कान तलकू गभीर कान पाखरे गभीर क्षत चिन्ह थाई बाम पाट गाल तलकू एक गभीर क्षत चिन्ह थाई मुंड तलकू कटा दाग थाई ओ मुंडर विभिन्न स्थान रे पोक लगी थाई पाएगला कौन सी धारु अस्त्र द्वारा हणा जाइथिबार जणा पडुथाय.
This has happened in 18 at 10:50 a.m.
No, but signature is on 17.
Well, see that is the top 18 and overwritten.
Signature on 17.
And it is time is something else. It was overwritten again. and thereafter 10 p.m. a.m. it is written. All are overwritten.
Next,
and signature is on 17. 17.8. And the top it is written 18.8. What kind of inquest is this?
No, we should direct investigation of action against that officer.
Whether this inquest is on 17th or 18th? Just check it up at the top. First column.
My lord, it is written as 18.
First column it is written, overwritten.
My lord.
And the time is also overwritten. 10 something is written here. And thereafter in the bracket, 10 p.m. Thereafter, if you come to the down signature, it is 17.8.
Even with the death of a cattle, more seriously matter would have been viewed. Yeah, that it is very, very the investigation, quality of investigation. It appears everybody has harvested this.
Next inquest, my lord. Three inquest.
There are three inquests.
Yes. One is for the head, another is for the trunk, and third is both. No, joint.
Okay.
Joint. The
who joined?
The police.
Because that person is examined.
Police. That is the duty of the police. Police will conduct the inquiry.
Wait, it is your version. You are asking to presume things. Whether any witness has said that.
It is signed by the police.
It is all right. The severed head, because according to prosecution, it was brought from that side. Then somebody should bring it. If it was there in the police station, then naturally that has to be brought to the house of the accused, where the torso was waiting there. Then who brought is one thing that is missing. Who joined severed head to the torso, and for photograph purpose, for inquest purpose. Even that person who did it is not working.
See, the third inquest report is 17.8 at 5 p.m.
5 p.m.
Read that report.
ମୁକ୍ତି ରାଇମଣି ହେମ୍ବ୍ରମ ମୃତକ ଦେହ ମୁଣ୍ଡ ବିହୀନ ଚଟିଆ ହେମ୍ବ୍ରମର ଘର ଭିତରୁ ପଡିଥିବା ଅବସ୍ଥାରେ ପାଇଗଲା। ମୁକ୍ତି ମୁଣ୍ଡ ବିହୀନ ଗଣ୍ଡି ବେକ ପାଖରେ ଥାଇ ପୂର୍ବ ଦିଗକୁ ବେକ କଟା ହୋଇଥାଇ ଡାହାଣ ହାତ ମୁଠା ହୋଇ ଅଧା ବଙ୍କା ବେକ ପାଖକୁ ଥାଇ ପୂର୍ବକୁ ନିର୍ଦ୍ଦେଶ କରାଥାଇ ବାମ ହାତ ସିଧା ହୋଇ ଖୋଲା ଥାଇ ଦକ୍ଷିଣ ଦିଗରେ ରହି ଦେହରେ ଲାଗିଥାଇ ଗୋଡ ଦୁଇଟି ପଶ୍ଚିମ ଦିଗକୁ ଥାଇ ଅଧା ଭାଙ୍ଗିଥିବା ଅବସ୍ଥାରେ ପଡିଥାଇ ପାଇଗଲା। ସାକ୍ଷୀମାନଙ୍କ ସାମ୍ନାରେ ମୁକ୍ତି ରାଇମଣି ହେମ୍ବ୍ରମକୁ
The second inquest, it said that the insects were there. The
maggots were there.
Maggots were.
Maggots are formed within how many hours after death? What Modi on medical legal jurisprudence has said now?
Just check it up, because see, in the first inquest, you will find that the where in the first, just see first one where it says that mundo poko lagi. There the manipulation has taken place, overwriting and all. So therefore, the Modi jurisprudence you have just seen.
How many years?
No, Modi has given one chapter on that.
Whether it is an 18 or 17.
During my student days, Modi has said, after so many hours, the maggots are formed. And if the maggots have formed, then they also have to be dissected to decide what exactly is the cause of death. That's how Modi's medical legal jurisprudence.
But the first inquest report has to be discredited because of the manipulation. The dates.
And it's not endorsed also.
Clear cut.
But the larger
maggots,
question
maggots
would be, if the confession is not taken into us, 27 in view of the contradiction of PW1 and PW10 goes, then there is absolutely nothing in this case.
To connect the accused to the commission of murder.
Except that death is homicidal, there is nothing.
No, death is homicidal is operant. But how to connect the accused to the commission?
The other chains are all not
missing.
True. Beyond reasonable doubt. Hence,
but one connecting link is he lost 2 of his relatives. And he believed that it was because of witchery of the deceased victims.
That motive.
Motive is proved.
Motive is proved by the IO.
IO only. There is only IO evidence. Police evidence. No witness, nobody is said. Rather, PW1 says that they have a good relation.
Lost part of
contrary
the position.
Contrary.
And the child also, PW2 is the child. They also say that we don't know why this was.
What PW10 says regarding the inquest. Because the body part is, inquest of body part is done on 17. And head is done in
18.
17? Manipulated to 18.
My lord.
Manipulated to 18. What is the reason? What the IO says regarding that? Inquest.
IO, my lord, has not.
Inquest part.
You get let them get full particulars of that police officer who conducted the investigation. This is and the forensic lab officer who have not furnished the report. Give full particulars of those officials.
And take a serious view because these 4 people, somebody was killed in this manner.
8 to 24 hours. 8 to 24 hours. Therefore, maggot is formed when the second, third inquest is made. Yes, that can even second inquest is made. Maggots are formed.
Yes, second inquest on 18.
So then the first inquest, the first inquest report which is manipulated is really done on 18, but signature is obtained on 17.
It is very short.
Yeah, signature of the police.
Police officer.
Who conducted the inquest.
What is that?
Full particulars of that officer.
Name is also not. It's very difficult, very poor.
Officer is B Bag. His name is B Bag.
Accused or anybody related to accused, associated with any political party or politicians, power holders.
They are
is available.
The accused person is the accused person. Tribal, my lord, it is not.
I'm appearing as an amicus. He has not been. I'm not his counsel.
The accused person and a witness all are
tribals.
So that possible is not there.
If tribals die, we need not much worry at all.
No, my lord. The possibility of tampering with evidence
is less.
That is less.
It's casually done.
Yes.
He is
His name is PW10 is Biranchi Bag.
You get full particulars of that police officer and the official of forensic laboratory. Perhaps also make an real algorithm. So that you have to make some observation.
Let us see 313. Any stand taken regarding motive part?
So deny.
Never motive
he
part.
wasn't present, what he says.
Just see motive part.
13 would be page 29. 29 of the TCM.
Just 29.
Page 29 of the paper. PDF page 39.
33.
39.
39.
It begins.
Go to 39.
And on top, this language issue is paper book page 29, PDF page 39. On top, this language issue is also further ratified by the session judge himself.
Ask him to go to 39. It's 29. Go to 39. 39.
TCR version 39.
That itself is fine.
The judge is explaining in Oriya to the interpreter Rameswar Hansa, who interpreted the same to the accused in Santali language.
This ratifies that his language, this is vis-a-vis the judicial confession, of course.
No, the motive part of the evidence, it comes from the mouth of whom?
From the IO, but
How
there is no
IO
questioning on this point. There is no questioning.
How? And then motive also falls down.
Yes. Accused statement in 313, there is no questioning.
So that circumstances also you could not prove on record.
This a case of homicide is undisputable.
Yes.
Indisputable. But the linking of the accused to the commission, there
homicide the undisputed and the extrajudicial confession also undisputed.
What extra? It is not. It is by the interpreter.
No.
Interpreter is not examined.
The accused confessed before police with the quoted that he has committed the crime.
On
that circumstances was not taken as a circumstance by trial court. Now we are started wired by saying that.
That's something, but in
very
313, I believe that has not.
That we are examining now. And subject to what Mr. Mishra is going to tell us tomorrow or day after, whatever. But that part we are examining. Whether that could be treated as an extrajudicial confession or what. What is the nature of that confession?
Actually, when at what time he made that confession?
Yes.
And
what time thereafter the FIR came to be registered?
And very interesting. What the confession he made, it is reduced down to writing, it seems, by a report.
Police.
That is their merit. One stationary entry.
And that should have been treated as an FIR. In true sense.
Yes.
FIR comes subsequently.
Disclosure cognizable
offense. That's the first information.
Not disputed that he walks into the police station and this conversation is between him and the police officials. There is no independent person before whom this happens. Had the independent person been there, then extrajudicial confession, there is no dispute, it comes in. But whether it can be made, whether that still what he has done would amount to extrajudicial confession, I'll get back to you.
That's all.
That's something I
Whether this has been done in presence of other police officers, they should have taken any other police officer to say that yes, it has been done in our presence or something of that sort. Nothing is there on the court. And the same person is investigating. As if with the police station he was alone. And you have not examined that Hemram who was asked to guard this accused and read accused.
And that also, that stationary entry was also not executed.
That even if you take it as a confession, that it goes out.
Yes.
That is not taken on record. What will you do with that confession?
We, my lord, have gone through the yesterday night. I submitted that this is a worst case for the prosecution.
Very difficult. No, see,
but
in a so casual manner, this investigation is done in a matter of this nature.
No, it is
heinous crime.
It is not done even by casual manner. It is some other new word we have to invent for that.
Inexperienced person has.
What is the experience? He says that I have intimated the SP of the area. It was brought to the notice of the SP, superintendent of police of that area. Thereafter, this is happening. You don't treat these people as human beings. That's the whole difficulty.
Another facet would be that he walks from his, suppose if we accept their case, walks from his house to the police station, 7 kilometers in broad daylight. There's no independent evidence coming forward. Nobody saw him. He walks like this. There's no linking. Only the IO's evidence has been.
No, that part we have to visualize the geographical area, my lord. Hill, jungle, everything is there. There is no possibility of.
Did he go to police 7 kilometers?
7 kilometers
Did he
by
go by
river.
walk or on vehicle?
What?
That
He went by walk. Nothing is there.
to river it is 7 kilometers. Otherwise by Pakka road
45 kilometers.
40
kilometers.
Hill river, it takes 7 kilometers. Usually they walk.
No, we can't assume in the civil side we can do. On criminal side, everything has to be a little evidence is necessary. It's not
Preponderance of probability.
It is not by preponderance of probability.
I'm grateful.
A date will be fixed so that it can be closed.
Date is
Because
already
the accused has already served his substantial sentence.
Up to Mr. MISHRA, day after tomorrow?
Means any date convenient to your
Next week, my lord, because I have to examine the detailed TCR to assist your lordships.
And he has prepared a written note.
My lord.
And you also prepared
Yes.
so that giving and give it to him.
Yes, ma'am.
Give full, furnish full particulars of the police officer and that forensic laboratory officer.
Time and dates, very important.
Madam.
In all these things, the sequence.
Next week, anything?
Monday? We'll recall that the WP order, that madam, shall comment or do. We can take up the, which will dismiss it now. This one.
Tell her to give written note.
Yes, okay, recall that order.
Judgment reserved, written note of submission to be filed by both.
My lord, judgment, tomorrow.
Put it tomorrow.
Tomorrow. So, and tell them.
Tell that madam, what is her name? Huh?
Let it come after 2 weeks because she should not think that we are angry and we have therefore written the order. Let it come after 2 weeks.
And see, write down part heard, partly heard. Then will counsel for the petitioner seeks adjournment for filing written note of submission. These matter for further hearing. Let me come with it.
Correct.
And I'm deeply grateful to your lordship.
Yes, thank you. Yeah, you are very good both in civil and criminal law. I have been seeing you.
Try my best.
We were thinking that you are civilized.
I'm grateful to you.